number 2, item number 4 to 7. Page number 3, item number 8 to 12. Page 4, item 13 to 19. Page 5, item 20 to 23. Page 6, item 24. Page 9, item 25 and 26. Page 10, item 27. Page 13, item 28 to 31. Page number 14, item 32 and 33. Page 15, item 34. Page number 16, item 35 to 38. Page 17, item 39 to 43. Page number 18, item 44 to 47. Page 19, item 48. Page 20, item 49 to 51.
Pardon, my lord.
Yes.
My lord, this is item number 50, wherein I am appearing for the opposite party. Number 2,
Yes.
Odisha Real Estate Regulatory Authority, my lord. And we have filed a counter affidavit. Today I have spoken to the petitioner counsel. I'll serve him a copy, my lord. Let's fix up a date for that matter, my lord.
Just wait.
With your lordship's kind permission,
So go take a minute.
Just a minute.
Yes, that's
may I beg to mention item 49?
We'll sure. Just
Mr. Rai, one mention is in the process.
Okay. I'm so sorry.
when have we filed this counter affidavit?
My lord, we had filed this on 9/8/2023, my lord.
Upon record.
There's an affidavit filed by opposite party number 2, pursuant to the additional affidavit filed by the petitioner on 4/5/2023.
Yes, it is there.
Affidavit is there?
I have got a copy of the filing slip also.
No, no, it must be noted there.
It is filed on 9th August. Filed on 9th August.
Yes, yes, madam. 9th August, madam.
All right. Mr. BP Tripathi, and counsel appearing for the petition of the response.
Opposite party number 2.
Opposite party number 2 has stated that in response to the additional affidavit filed by the petitioner, the said opposite party has filed the counter affidavit. However, he could not supply a copy to the counsel for the petitioner as yet. Let the matter be listed on 13th of September 2023.
Deeply grateful, my lord.
That's 49. Can I mention my lord now?
49 years.
49, my lords, with your lordship's kind permission. This is that matter, my lord.
I understand.
Home for
Just you will take up the matter at 12. Please inform Mr. P.K. Padi.
marriage.
You sent some of your juniors.
Marriage.
3 o'clock. That's 3, you can do that.
Marriage. That's because I find that everybody is interested to do the case. So there has been no adjournment till now.
No, everybody should be that also the practice of the court.
Right.
Despite our inability to take up all the matters, those are taken on board.
Right.
I'm thankful to the bar.
Right. It will be taken. Can it be taken up at 3 o'clock?
3 o'clock, that is
Well,
my secretary suggesting.
Yes.
Yes.
Then I'll inform you.
Page number 23, item 52 to 54. Page 24, item 55 to 58.
In item 56, worship granted me to mention, on 10th, today, this will fix a time or maybe taken up.
You come at 12:30.
Yeah, everybody.
12:30.
Item,
Okay, so 12:30 call it. Yes.
item
You inform the other side, Mr.
Yes, I'm taking care to inform you.
page 25, item 59 to 62.
62, my lords.
Yes.
I may be bothered to mention, my lords. Because this is a matter I had mentioned and will come up on Monday, my lords. In fact, the state is also interested. My lords, it may be taken up at 12 o'clock because after lunch, my lords, I have an election case. The witness is there
Okay.
in the talk.
Okay. Any difficulty? 62?
Counsel for the petitioner is also here. State is also here. It's very short matter, Malad.
So come at 12.
Yes.
But make the short submissions.
Yes, Malad.
Because the mutation,
Will be
that is what.
absolutely
A report of the government is there. We have filed the report. And your lordship has called for that report, we have filed it. Now your lordship is to take a decision on the
All
basis
right,
of that.
all right.
Page 26, item 63 to 67. Let's move on.
Writ number 875 of 2022 is amendment specifically directed to the master to be listed on 12th July 23. But on that day, court could not function. That's why it has not been listed.
Gives that date on.
Have you checked if any other date has been given?
No, date has been given.
You checked
Yes,
on the website?
Yes.
Just check out the system first and then.
Let's see.
Start with the system whether any date is given.
No, I have one five.
I'll give you a shorter date.
Yes,
Just check.
but on that date, court could not function. That's why it is not.
I remember.
I may be pardon, madam.
Yes,
This is WA number 684 of 2022.
yes.
And that relates to the MS MED Act 2006. And I am the decree holder. And the execution case has been stayed by this honorable court since February of this year.
Single bench or bench?
Division bench. Let's see, it was in the list 3rd August, but due to the paucity of time, it could not reach.
Before our then?
Let's see.
Have you checked if another date has been given?
Let's see, date has been given, but that is given the September 5th of this year. So let's see, may prepone it. I have filed one IO to that.
It may be very difficult, Lawrence Council. Better you mention on 5th of September so that matter can be heard and disposed of on that day. You come prepared on that day. Whatever you have to prepare the synopsis of your submission and other thing you prepare, come on 5th of September. Because our board is seriously congested.
Let's see.
All right.
Obliged.
With your lordship's kind permission, I beg to mention that I filed a review petition. Review of the order passed by ex-Chief Justice, Justice Muralidhar and Raman. While arising out of income tax matters.
And yes, and one of your associate to the registered judicial, he will just bring it on the administrative side. Unless the bench is constituted, they cannot list the matter. So send a mention memo through your associate and he will bring it to me and I will give a day. Okay.
Much obliged.
I will review petition. Regularly order filed by the justice. I bring the person
With whom?
Honorable Justice, Chief Justice, Justice Dr. Muralidharan and Justice Z. Sarpati.
All right, you just same thing you do. Prepare a mention memo, mention it before the registered judicial. You will bring that mention memo in the administrative side. I have to constitute a bench for that. The bench is not available right now.
I have filed a writ appeal, my lord, challenging that the registered corporate society has not vested with the power to frame a rule, my lord. Therefore, I have prayed for an interim order that was not granted. Against that, I have filed a writ appeal.
It will be taken on the 18th of August this month.
18th above.
My lord, pardon to mention that the two cases have been also dismissed for non-prosecution, my lord. That is before the honorable Chief
You
Justice.
file it, it will be in due date, it will be taken up because we have to check up who are the which division bench.
Division before honorable Chief Justice and also honorable yes Raman, MS Raman.
Raman, you go to the registered judicial.
One criminal juvenile matter. The matter is posted to the assigned bench, but the matter is transferred to the appropriate bench as per the guidelines of Honorable Supreme Court. And my lord, in the meantime, the grandfather of the juvenile is died, and the principal accused is already on bail. So the matter is being
And which is the appropriate bench?
court number 17. The grandfather.
Yes.
You just go there. If you are not having the code number 70 right at this point, you go to the registered judicial. This bench is not appropriate bench
My lord.
for this subject matter. Okay, go to the registered judicial. Give the reference of my statement to you and go to the registered judicial.
I need pardon, my lord.
Yes.
You applied for interim bail?
No, my lord.
Yes,
Regular bail?
Mine.
Sorry.
Just readable file by state. So you'll also fix any date next week, might.
Just fix it. Looking
Hello,
at just fix date, huh?
My lord, I'm extremely sorry, your lordship. Item 26, I just missed it, your lordship.
No, you have to wait then.
Okay. Just a prayer that it has to come with along with another date, so.
All right, Mr. Mishra, wait.
Oh my lord, no question.
My
Press the application, lords.
All right.
my lord, my pardon, make a mention. My lord, my pardon, make a
Yes.
item procedure from my lord, imbue, my lord.
Item?
May I pray? Item 4, my lord. Item 4.
Just you wait. When the item number 4 will be taken up, you make your submission, okay? Yes.
Yes, sir. May I call the list? Weekly list, fresh admission item number 1.
Item 1, my lord, on last occasion, your lordship. In item 1, last occasion, your lordship, my director will take instruction. May I place short accommodation till Wednesday, day after tomorrow, my lord. Or your lordship may take it up after lunch. If your lordship.
Up to last, no, it's fixing a date on 18th.
Well, day after tomorrow, that instruction with me.
All right.
Right. Yeah.
17th. You're fixing on 17th of August.
My lord.
All right. At the request of Mr. M. Let the matter be listed on 17th of August. Yes.
Item number 2. Item 2.
Who is appealing to the petitioner? Appellant.
There's actually come up for engagement from council.
That is good.
Given administration mission and he has already filed wakalat.
Someone has filed the wakalat now?
Affidavit filed by the wife of the appellant asking for engagement. And that advocate has already filed wakalat number, noting he has not taken consent from the previous council. If appellant wants to engage.
Who is appealing for any lawyer is coming for this appellant in this matter? None appears for the appellant when it is called out. Let the matter be listed on 21st August 2023. If on that day there is no representation for the appellant, this court will be compelled to engage a legal aid counsel for presenting the case of the appellant. Who is appealing to the state in this matter? Mr. Tripathi.
Rajesh Tripathi.
Mr. Rajesh Tripathi, and Council of Additional Standing Council appeals for the state. Yes, next.
Item number 3. Permitted to withdraw the petition memo.
Have you filed this, the memo?
Memo.
All right. Mr. SP, Learned Council appearing for the petitioner has submitted that his instructions to withdraw this petition. In support thereof, he has filed a memorandum.
8th August 2023.
All right. Well, the memorandum dated 8/8/2023, seeking leave of this court for withdrawing the said petition. Prayer stands allowed. Let the matter be, this petition stands dismissed as withdrawn.
Urgent copy. Item number 4.
Urgent certificate copy be granted as per rule. Mr. Behra, are you appearing for the state?
I'm appearing for the state.
Mr. A. Behra, A.K. Behra, Council appears for the, you are Mr. A.K. or A?
A Behra.
A. Behra, Council appears for the state opposite parties. Next.
Item 4.
Item from my lord, Honorable Mr. Devasys Sahu, he is suffering from.
Yes. What is your prayer, Mr. Mishra?
The council, Mr. Sahu,
My lord,
All right. It is stated that Mr. Devasys Sahu and Council, who usually appears for the lead appellant, is unwell today and is not attending the court. In view of the above statement, let the matter be listed on 5th of September 2023. Advance from the opposite parties. All right.
Non-filing also.
So in the meanwhile, the appellant shall invariably file the certified copies and
Copy of the judgment.
due application for condonation of delay.
6, 7, or
Yes.
Item number 5.
my lord, sir. My lord, sir, private opportunity, no more, he'll file substitution.
The 15 days time is enough, I think.
I am for the appellant.
All right.
Notice had gone in the limitation matter.
So you will take steps for substitution.
Let him give the information so that.
Information is supplied to the appellant and they will take steps. Mr. P.K. Mahapatra, who passed away?
Private opposite.
Only one opposite party.
Respondent one.
Respondent number 1. Mr. P.K. Mahapatra, Learned Counsel, I think the respondent number 1 has a reported death of the opposite party number 1, the respondent number 1 struck. Let the matter be listed on 5th of September 2023. We would request Mr. Mahapatra to supply the details of the legal years of respondent number 1 to Mr. S.M. Das. No, he is appearing with you, Mr. S.M. Das.
Yes. Mr. Pranay Mahant is there. He is there.
Yes, to Mr. Pranay Mahanti, Learned Counsel, appearing with the appellant. Stop. This information be supplied within 3 days. Can you do that?
My lord,
Within 3 working days?
I'll try my best, man.
3 days.
What?
Within 3 working days. Supply this within 3 working days.
Typographical error in order to identify for. If the year of the arrears are on.
Let us ignore it.
Mr. Mahanti, have you checked? Office has pointed out that the year of the IAs is incorrect.
Well, that is in the order of the Honorable Court.
That is why I'm asking, have you checked? This is all right. This, what they have pointed out.
That should be corrected.
All right, that should be corrected.
That can be corrected. But your lordship may just indicate that correction.
Yes.
No, this is not. We are just mentioning in the order, nothing else.
Mentioning that there is a
Not
mistake.
necessarily.
That's all.
This everybody understand that.
Not so material.
This will be of the year.
2021.
21.
In the order dated 5/4/2023, while putting the case number, we're typing the case number, interlocutory application numbers. In the year of those applications, a mistake has crept in. Stop. These IA numbers 2467 and 2468 of 2022. The IA numbers is typed as 2467 and 2466 of 2022 shall be IA numbers 2467 and 2468 of 2022. Necessary correction didn't be made. All right.
Will be 21.
21. It will be 21. Last one will be 21. Yes.
Item number 6.
Seven.
Item 6. None appears. Release the matter on 21st of August 2023. If on that day there is no representation, will be compelled to pass an order for non-prosecution. Next.
Item number 7.
But at 7, your lordship may treat as sufficient because already delivered.
All right.
My lord, I am for the respondent number 1, my lord.
You are appealing for the respondent number 1.
My lord.
Have you filed Vakalatnama?
Well, today I have filed.
All right. What is the good name, sir?
My lord, S.K. Garnaik.
Mr. S.P. Garnaik,
SK.
S.K. Garnaik, Learned Counsel has appeared for opposite, this respondent number 1. Mr. Garnaik has stated that he has filed the Vakalatnama.
My lord.
Filed the Vakalatnama today. So, as the service is complete, let the matter be listed.
Well, same day at that of item 5. Similar matters are there. 5, 7, 8, all
5, 9, 5, 9, no?
Yes, my lord.
5, 9. 5, 9, it will come again. Mr. P.K. Mahanti, and senior advocate, assisted by Pranay Mahanti, appears for the opponent. All right.
Item 8.
Already it also same position, already delivered may be treated as sufficient.
You are appearing.
My lord. You are appearing.
Got it.
You are in the same order. It's
Nine.
date, huh?
Nine.
Same process. Okay.
Item 9.
My lord, 9 and 45 also same.
All right.
45 should not have been listed under heading of admission. This same matter. Similar matter. In limitation matter.
All right.
45 also apply.
What is about 45? What about the 45?
45 years also, that is also delivered.
He is appearing or somebody else?
My lord.
45 you are appearing.
My lord.
Then just copy also the same order.
Should they be listed together or separately?
No, they're listed together, 45.
My lord, list, maybe list together.
So the 45 also.
Right.
Yes.
My lord, in limitation matter, notice had gone. If you had to file any objection, let him file. Otherwise, that day is
Keep it live. In the meanwhile, the respondents may file their objection if any in respect of the payoff of condonation of delay.
no blast.
Item number 10.
Yeah, my lord. I am ready, my lord, day after tomorrow.
Day after tomorrow will be difficult. If you are ready, start submission today itself.
Or a long
Next
day?
week,
No, because it's a huge list every day. It is coming in.
next week, my lord.
It cannot be next week. It will go the last week of September.
What are those defects,
Some
Mr. Rao?
defects are there.
Remove.
Yes. Properly paid mark, my.
All right, Mr. K.K. Raut and counsel appearing for the appellant stated that the remove as identified by the registry has been removed.
No, he will.
No, I will remove within 2 days.
Wait for some accommodation today for removing the defects as identified by the registry. And the matter will be listed on 31st of August 2020.
No, date check.
Who is appearing for the state in this matter?
Item 10.
I reflect your name, Mr. Kumpia.
Yes.
Mr. M.K. Kumpia, National Government.
Copy not, sir. Copy not, sir.
No, already, sir. I would be,
That 5D is that defect.
I will serve an
Item 10.
Item number 11.
obliged.
In item 11, my lord, notice already issued, it appears from the noting, item delivery confirmed.
All right,
So there is a limitation.
The date of appearance.
all right. Because nobody has appeared, we fix a date.
My lord,
And the matter will be listed on 12th of September 2023. It appears from the registry's note dated 14/8/2023. No, sorry, 12/4/2023. That the notice is sent by the registered post has been delivered. Yes, sir, the service is complete. If on the next day there is no representation from those respondent number 1,
Noting is dated 10/8. Sometimes confusing because they write the date on top. So
so this.
he signed and put the date below.
Right. We shall proceed in absence of the respondent number 1. Mr. M.K. Kuntial and additional government advocate has appeared for the appellants. Next.
Item 12.
The consignment had been delivered. Lottery treated it as sufficient. Non-opposite partner proof. That's the report of the registry.
All right, just let me check the date. Yes, from the registry's note dated 2/5/2023. It appears that
No, it is 10/8/2023. 25 was the order. With that nothing, this is.
10/8/2023. it transpires that the registrar's notice, the delivery of the registered notice was complete and asset service stand complete. But there's no representation from the respondent number 2. Okay, also right, the registered notice issued on the respondent number 2 has been delivered. Stop. But none appears on the respondent number 2 and the matter is specified today. When the matter is listed again on 11 September 2022, Mr. M.K. Mohanty, learned counsel appears for the appellant and Mr. G.K. Mohanty, learned government advocate appears for the respondent number 1. 11th of September, it will come.
Next, item 13. Item note 13.
None appears less than 31st of August 2020.
So this was our case, a letter has come from the JMFC asking for frustration. That is
My lord, it's a disposed of case.
All right, because of there is a letter from the
extension of time.
civil just
That can be
extended.
30th of August was the date by which judgment was to be given.
You are appearing?
I was the appellant, my lord.
All right. What was the election? What was the time earlier granted?
30th of August.
30th of August.
30th of August.
11/5.
Can you say that what is the stage of the case now?
Well, all evidences have been closed. Now is posted for final hearing.
So maximum 15 days time will suffice.
11/5 order has not been scanned.
That is your instruction.
Yes, madam. That is
only for the hearing.
Madam, the matter is posted for hearing now.
All right. We give them more 6 weeks time for writing the judgment and everything also. And from 6 weeks from the 31st August 2023. But this matter has been listed before us in view of the letter number 370 dated 31/7/2023, which was received received by the registry on 2/8/2023. The civil justice JMFC Kujong has written this letter to the court for extension of time for completing the election case in terms of the order dated 11/5/2023, delivered in WA number 299 of 2023. What is the line you have written? The full line you read. The deadline is set up by this court was 1/2023. Stop. It has been stated by you are Mr. A. Behera.
A. Mohanty.
I was stated by A. Mohanty, learned counsel for the appellant that case is now posted for hearing. Stop. Keeping that statement in view, we grant another 6 weeks time for completing the said case. The said 6 weeks time shall start from 31/8/2023. The civil judge.
Start from 31/8.
JMFC Kujang.
The civil judge JMFC Kujan shall complete the said proceeding invariably by the extended date. Stop. A copy of this order be immediately communicated to the civil judge come JMFC Kujan. Stop. A free copy of this order be also furnished to the council for the parties. Stop. Just somewhere you write Mr. D.K. Mohanty, the Asian government advocate, appeared for the. You are appearing for the
Election officer is there.
Appearing
That
for
is
the state of Orissa.
Election officer.
Election officer. Okay.
Otherwise, it is a private dispute.
All right.
Item number 14. Item 14.
None appeals. List on 31st of August 2023. If on that day there is no representation, will be compelled to pass an order for non-prosecution. Item 2, appeal for Collector Ganjam in the earlier case.
No.
No.
Item 14.
I am not. Who is appearing?
The Collector Ganjam is the.
Yes, madam.
You are appearing?
Number 9. File is not.
Because he has not served copy, defect number.
Yes, that is there. That is why, madam. They have not served copy to us.
Okay. All right. No copy has been served in the government council before filing the appeal. Okay.
Next, 15.
No, please. There is a delay of 47 days.
Defects.
Days.
There is item of 15.
15. What are the
15.
defects, Mr. Kuntia?
Defect. That will be removed.
Certified copy not filed?
Yes.
That is 5A.
At the request of Mr. M.K. Kuntial and additional government advocate, let the matter be listed on 21st of August.
Madam.
August 21st of August. Meanwhile, the defects as identified by the registry shall be removed. Next.
Item 16.
There is also delay.
No, just first remove the defects. Then we
In
will
item 15, that certified copy we have filed. Ask
Notice
is
not filed.
noting that we are filing it now through e-filing, that copy with us.
just
That is why the
indicate
defects
to the registry, we will take up the matter on 21st of August. All right. Now you called 16.
Item 16.
In 16, there is a delay of 400.
16, I think you are not the.
Yes,
Oh,
please.
yes, 16.
Orissa.
All right.
State.
Pages 42 to 50 not legible. What is it? The petition?
Check the read petition.
Pages 42 52 not legible.
Files submit that legible. That is the read petition copy.
2007, so they must have been giving those
So that-
carbon.
That's why we are facing difficult when we are.
File the certified copy.
Yes, madam. Certified copy will file it. But so far as that legible copy, that is the part of that read petition, we are annexing it to our read
All right,
copy.
file it. Yes.
My
Just
HML
put down in I number 4449, 449 of 2023. There is an application for dispensing the filing of the certified copy of the order dated 11/2022, passed in WPC within first bracket OSC number 2201 of 2007. Mr. Kuntia, M.K. Kuntial and additional government advocate submitted that they have already filed the certified copy of the impugned order. In view of that, we dispense the filing.
in item 17, we have not. In item 16, we have filed. In item
This
17.
is 16. This is 16.
Oh, sorry.
You filed the dispensing with petition. So if you file the certified copy.
We dispense the filing of the certified copy. Stop. The SR has not been done.
Done.
It was
Because
stopped.
that dispensing with thing is there. So
Since the certified copy has been filed,
Not filed.
the dispensation shall be effective till the date of filing the certified copy.
In item 6
Thereof, the application stands disposed.
content.
Just a minute.
So 16, have you filed the certified copy? The
No, sir.
order is that you have filed.
or we have filed
State clearly.
we have filed in 16 we have filed the Xerox copy. In 15 we have filed the certified copy.
You told the secretary.
Sorry, I am 15, 17. I was concluding 17. 17 is 17 not our mine. So in 16 we have filed only Xerox copy.
Okay, scroll out the order. This is just case number is same. Mr. M.K. Kuntial and counsel appearing for the petitioner has submitted that since they could not obtain the certified copy at the time till the filing of the connected writ appeal being WA number 1654/2023. This application has been filed seeking dispensation of the filing of the certified copy. Stop. You dispense the requirement of the filing of the certified copy, subject to condition that within 30 days from today, the certified copy shall be filed without delay. According to this petition stands disposed of. Now there is a limitation petition.
Yes, yes, ma'am.
In I number 4448, there is a limitation petition. Earlier petition you have written?
The limitation
Right.
mine files for 63 days.
Mr. M.K. Kuntial and National Government Advocate is an application for condoning the delay. According to the report of the stamp reporter, there is a delay of 465 days in filing the WA, in filing the intercourt appeal from the order dated 11/3/2022, passed by the learned single judge in WPC OAC number 2201 of 2007, issue notice as to why the aforementioned delay shall not be condoned or any other order or orders as deemed fit and proper shall not be passed. Notice is made returnable on 21st of September 2023. Steps for service on the sole respondent shall be taken, sole opposite party shall be taken within 3 working days from today by registered post with AD. Yes.
A small prayer in this case, my lord, that contempt has been fixed to 16.
Sorry, 400 days delay because you are sleeping on now the contempt you come when the contempt matter notice has not been issued in contempt matter.
Yes, ma'am, that has been fixed to 16th.
Just file this statement before that we have already filed an appeal. I think contempt case will not be proceeded. Well then, otherwise if you file any difficulty, come, we'll pass the order. Because it is a 400 day delay. Right has been already accrued in favor of the writ petition. Yes.
Item 17.
May I please? Your petitioner, who is a social worker and 100% visually impaired, has approached your lordship in the form of PIL, against the government in not discharging his statutory duties and the constitutional duties. More particularly, you also kindly say annexure 1. Just a glance, only one thing. I'm just relying, you may speak your specific directions, specific mandate words. You just kindly say annexure 1. This is one instance. I'm just giving. Where, my lords, there is no government recognized special school for blind, deaf, and dumb functioning in our district. In one district, there is no schools. Though you also kindly just a glance, section 16 of the, there also no section 21A, so far the children's villas up to 14 of years, the government is duty bound to provide this minimum facilities and schools, and you will also
You know, the notice has not been issued in the asking the government to respond.
yeah, all
My lord, perhaps similar case, he has filed another case of similar nature. Good. ଆପଣ ଆଉ ଗୋଟେ କରିଛନ୍ତି ନା
details. Two cases, one is for special school, one is for general school. And constitutional mandate is same.
There is no specific allegation as your lordship will find.
Oh, allegations, no possibility in exploration of this setting of a special school.
Okay, we'll discuss.
In the district, not a single school is there.
That is what annexure 1.
This we are exploring only. There is a possibility or not. Or just a DK Mahapasaral and council appealing for the petition. By means of this public interest litigation, the petitioner has asked this court but directing the state to provide necessary infrastructural facilities to the special school founded by the government, such as the fireproof house, drinking water, and study material, and to establish and operate special school for students with multiple disabilities, and for that purpose, for allocating and to allocate sufficient for that purpose to allocate sufficient resources to meet the requirements. So issue notice returnable on 21st of September 2023. Since Mr. D.K. Mohanty, learned additional government advocate, appears and gives notice for the opposite parties. The purpose notice is called. We would direct the opposite party number 2 in particular, give the details of all the districts of the state of Orissa, in respect of the facilities available for the specially able young people, so that the educational infrastructure is concerned. So give all the districts what are the other facilities are available, because there is a special department under the government.
The SSCPD department is also.
All right. They are not made party.
Yes, yes,
Directed the commission at number 2.
Yes.
the commission.
File the affidavit. All the next.
Isn't the same?
That
Mr. Mahapatra, this is the same person or two different persons?
the same persons,
And why have you described him differently in the two writ petitions?
differently.
See the name.
Manoranjan Jena. Spelling
Mistake.
spelling
Same order.
Ramchandra Jana. But there is
same order.
same name is there. Manoranjan Jana and Ramchandra Jana.
MANO it is.
Sorry. That is the type of, but same person.
Same order.
Same person. Person.
No, there is a difference is there. Just to be partly changed, this code
School and nursing department, because it's general schools.
to provide free compulsory primary education to all children with disabilities in terms of section 31 of the RPWB Act 2016, to ensure that every child with benchmark disability
Where can we take?
just has access to free education in an appropriate environment till he attains the age of 18 years as per section 31 of section 16 and 2016. So, that apart, it has been urged that the direction be issued of the higher education and higher education institution, higher education department and other higher education institution. No, directions on the government institution and the other higher education institution receiving the aid from the government to reserve not less than 5% seats for the persons having benchmark disabilities as per section 32 of the RPWD Act 2016. So it has been further stated that the state shall conduct survey of the school-going children in every 5 years for identifying the children with disabilities, asserting their special needs, and to extend the support they need for pursuing their life. So, as ancillary to the said rule, it has been asked that such survey shall be conducted within a period of 2 years from the date of commencement of the 2 years, That cannot be done from the date of commencement of.
That's wrong. That is
Wrong.
That is-
Yes.
that is a constitution, that is a mandate, but that has not been done.
That is not done.
Yes,
There's the such surveys.
There's a fix any day within
Included by the section 17 of RPWD Act 2016 has not been conducted in the state as yet. All right. Issue notice since Mr. D.K. Mohanty learned additional government advocate appears in with notice for the respondents. No formal notice is called for. This change it with another.
My lord, 8 weeks time can be granted because I have to collect, we have to collect data from.
All right. In
all
this case, we
8 weeks.
make it within the month of. All right, the 30th of September is all right?
30th of
30th of September.
My lord, free copy of the order.
Both.
Free copy of the order may be
30th of
supplied.
September, because a free copy of this order, both the cases is supplied to Mr. Mohanty and Mr. Government Advocate.
Both will come on 30th.
Both will come on 30th of September.
Yes.
So blessed.
We are blessed.
Item 19.
May I please? In this case, the petitioner has challenged the action of the opposite parties in not giving appointment to the petitioner as a notary. All the recommendations were made. This is second round of litigation. May I take your honor to page 29. In the year 2005, after completion of 9 to 10 years, he applied for the to be appointed as a notary, and thereafter all those it is admitted that the collector has recommended, the Secretary Bar Association recommended.
Mr. Madhuli.
Here, final order, you lords, my lord, we can see the final order at page 32.
49. Yes.
Fresh admission टा कहीं आपको जानी पड़ना है
Page 32. In inviting a reference on the above noted subject, I am directed to say that pursuant to direction of Honorable High Court, by the order dated 10/12/2012, filed in WBC number 5354 of 2009, it is stated that you were found unsuitable for 2 times before the departmental committee in the interview held on 21/11/2008 and 24/2/2009 for appointment as notary, for which your memorial has been rejected.
He was found unsuitable on what ground?
Yes.
That is not mentioned here.
That is the problem.
This was passed on in the month of December
2012.
Now, virtually, where
This writ petition of the year 2013.
notice has not been issued.
No, it had been dismissed for default for
2014
That has been restored by subsequent order.
recently, yes.
You file a short affidavit citing the grounds whether now whether on what ground he was adjudged that he is not suitable. Number one. Number two, after taking all the years of this practice, he has already completed more than 10 years again. Whether he can be
After
That scheme of 4 posts, he was the only candidate. No competent claim was there at that time. In 2000,
Dr. Das, if someone is not eligible according to the
yes, I am coming to that, my lord. Your notice will look to 25 years.
Still exists.
2008, when he was called for the interview and he was not given any intimation. Then under RTI, I applied for the same. 2009, I approached this honorable court. This honorable court's order is 29. They have mentioned that if you were kept silent after recommendation and all, and you have not informed, and you have not filed counter, then consider the case of the petitioner. And thereafter only, that order 29. For a moment, you need to pay.
Everything is all right. If someone is found not suitable for whatever reason we don't know, first of all, let us understand why he was.
Page 25. They are giving up.
I've seen there is.
Perhaps he was not found to be suitable. That is the order.
That doesn't make.
And from the order itself.
You were sleeping from 2012. We are
No, madam.
after a week. I asking the state to give the reasons why he was unsuitable.
Another small date does not matter.
21st of August. Let the matter be listed on 21st of August 2023. Meanwhile, Mr. P.K. Mudoli, what is that order you are referring to?
Page 32.
I have annexed.
Already.
After the order passed in writ application, then they have
Shall take instruction in writing why the petitioner was adjudged not suitable for engagement as the notary. Stop. We'll take up the matter for disposal on the next date.
that is again illegal from the act does not specify that. That order has been passed.
No, let them first, what is the ground? Let us understand that according to the act, we will decide the matter. That is why I'm posting it. You take by 21st.
Item number 20.
Yes.
Item 20.
My lord, in compliance of the interim order passed by this honorable court, in this case, we have submitted the report, the DFO along with the report.
My lord, item 20 has been fixed at 2 p.m. today.
Is it?
Yes, well, 2 p.m. My lord, it shows on the call slip.
Yes, okay. Okay.
Item 21.
May please your lordship.
Yes.
This is a public interest litigation, my lord. Matter relates to installation of CCTV camera and firefighting instrument in the different buildings of the SB Medical College, Cuttack. This matter, my lord, appears to be released as per order number dated 21st March 2023.
Yes.
Agreeing to passing of this said order, this honorable court had passed an order in order number 7 dated 23 January.
That was on that day was not available on record. It was directed. This
My lord.
said affidavit has to be.
My lord.
That affidavit is already.
That this honorable court had passed an order on order number 7 dated 24 January 2023. My lord.
Yes.
The paragraph of the said order is para 2 and 3. My lord.
Yes.
In obedience to the said order, the superintendent SB Medical College and Hospital has filed an
Reading.
My lord.
Where from you reading it? Page number. Because this counter affidavit to the additional affidavit dated 23/2023 was filed on 10th of August.
That is the counter affidavit. I will be petitioner to the additional affidavit. Additional affidavit is at flag of your lordship.
All right. Now you read 2 and 3.
My lord.
I got it. Read 2 and 3.
My lord. The paragraph of order number 7, that para 2 and 3. In obedience to the said order, the superintendent SB Medical College and Hospital has filed additional affidavit. My lord.
Yes.
That additional affidavit is that flag of your lordship brief. I would like to place the paragraph of this said
Yes.
additional affidavit. That is at Subpara 6 mailer.
Yes.
I would like to place the Subpara 6 mailer.
Yes.
Meanwhile, the fire officer of Central News Cuttack, by letter number 1523, 6 March 2023, has submitted a report regarding fire safety measures in respect of different hospital buildings with certain follow-up of action to be undertaken by this hospital. Accordingly, steps are being taken to carry out the suggestions given by the fire department in order to assess fire safety arrangements in the hospital. Carry out the suggestion given by the fire department. And thereafter, we have filed the counter. It is said additional affidavit. Dated 10th August, that is a flag E, my lord. That is my lord, flag E of your lordship brief, our counter. I would like to draw your lordship kind attention to the letter which has been issued by the fire officer, my lord.
That affidavit is not available on record.
My lord,
So find out from that physical record.
This one.
This council affidavit is the
counter affidavit.
Mr. Akshay Kumar Das.
Yes.
All right.
Counter affidavit is dated 10th. I would like to draw your lordship and attention to their additional affidavit, my lord, which is at subpara 6, my lord. Subpara 6, there are.
That you have placed.
That I have already placed. Thereafter, I want to draw your lordship kind attention to counter affidavit filed by the petitioner, my lord.
Yes, yes.
Which is dated August 2023. The relevant paragraph of the said affidavit is at paragraph 5 and 8.
Yes.
Paragraph 4, my lord, is at page 3, my lord. I would like to place paragraph 4 first.
Yes.
My lord. That the great government software of para 6, that steps are being taken to carry out the solutions. Number 153, that 6 March 2023, in order to assist the fire safety arrangement in the hospital. Solution given by the fire department, my lord. Thereafter, I would like to draw your lordship kind attention to para 5, my lord.
Yes.
Page 3, 4, 5. That thereafter the para 5, my lord.
Yes, yes.
That thereafter the office of the superintendent but communicated the information as sought for by the application but 11/4/2023 to the petitioner in letter so. Thereafter, I would like to next paragraph. After reading through the aforesaid information, it is found that no positive action is taken by the authority of hospital in response to the letter 6 March 2023 of fire officer Central is cut off, except some correspondence have been made to the chairman civil Commissioner Kotak Municipal Corporation and Superintendent Kotak R&B number 1. Letter number 76 dated 21st March 2023 for submission of plan approval. Therefore, we would like to draw your lordship kind attention to Annexure 3. Annexure 3, my lord, of our counter that is 30, my lord.
Yes. Yes,
my lord. It's 30 annexure 3, my lord.
Yes.
That is a better communication where we can action taken in respect response to letter 6 March 2023 on the basis of the letter issued to chairman so and so. Letter number 1, for submission of plan and approval letters in respect of different buildings of the fire safety. But to date, no complaints report has been received. That is their letter, my lord. Thereafter, I would like to draw your lordship's kind attention to Annex 4, my lord.
Meaning that these
Received from the said departments. No complaint. The reply of the PIO is that till date, no complaints report has been received from the departments from whom the information or the
but this flag D counter affidavit. Yes, it is also very vague and indefinite terms.
No, that your lordship may kindly see the order after the 2 weeks of the order. It was the letter. It was filed.
Yes,
I am just placing before your lordship. The counter was filed. Yes, on 20th March, and the letter was 6th March. Just 2 weeks after. So after 20, if your lordship will direct, we will give the current status because it is an old
status and we want the compliance report because you agreed to set up all these things.
Now, for that purpose, we have sought for the necessary arrangements from all the authority because not the medical college is not the sole authority because CTA, municipality.
I understand. What is the CDA's role in this?
No, that approved plan is to be supplied and accordingly there are some technicalities are there.
New buildings will have those fire alarms. That is not a problem.
This is all relating to old
buildings. You have to have something.
Those are constructed 60, 70 years old.
We understand all these things, but you are delaying the matter. At least you show us that you have just drawn up the design, sent for the CDA for extension.
May give me 3 weeks time. I will give this current
3 weeks time. But that if you do not submit all the particulars before this court, we can pass the adverse order. Usually, we do not do in a public interest litigation.
I have got a small submission to make if your lordship permits.
Yes.
This matter we have filed in the year 2015, my lord. Now we are in 2015.
The person is continuing cause of action.
Yes, that is not there because of the efforts. At least you have reached this far.
My lord.
Lessons have been made. Effort of my learned senior.
Service has not been complied. Nor they have adopted this. For that, let them file the valid fire safety certificate, my lord. Which will require must. Or will mandate.
Yes, it does. Counsel appearing for the petitioner. A Mahanti.
My lord.
Counsel appearing for the petitioner. Mr. Mahanti, when counsel has taken us to the additional affidavit by the opposite parties for showing their stand as reflected in para 6 of this said affidavit. In para 6, it has been stated that as regard to the fire safety arrangement in the SCB Medical College, the fire officer Central Range Cutter was requested by their letter dated 3/2/2023 to submit the status report of fire safety arrangement of the SCB Medical College Cutter. Simultaneously, the hospital manager and workshop in charge of the said hospital were instructed by the office letter dated 17/2/2023 to assist the team of the Orissa Fire Service for inspection of fire safety arrangement in different wards and buildings. Thereafter, it has been stated as follows. Meanwhile, the fire officer Central Range Kotak White, letter number 1583 dated DT stop 6/3/2023 has submitted a report regarding fire safety measure in respect of different hospital buildings of this hospital with certain follow-up actions to be undertaken by this hospital. Accordingly, the steps are being taken to carry out the suggestion given by the fire department in order to access fire safety arrangement in the said hospital stuff. In response to the said affidavit, the one additional affidavit are also been filed for the petitioner. In the said affidavit, the petitioner has clearly stated that the suggestion made by the fire officer has not been complied with. As a result, the hospital is running a high risk for delaying the matter. So at this juncture, Mr. D.K. Mohanty, an additional government advocate appearing with the opposite parties, has prayed for a very short accommodation.
May I be permitted to bring your lordship's attention this page 12, annexure C of my affidavit. It is specifically asked by the fire department that you have to produce the approved building plans along with plan approval letters issued by the competent plan approving authority in respect of the different buildings inside the premises of SCB Medical College. So these are the requirements which are to be procured.
Right. This juncture, Mr. Mohanty, Learned Council, having referred to the later dated 26/3/2023.
6/3.
26 or 6/3, sorry,
Yes.
6/3/2023.
Of the fire officer, Central Range.
The fire officers, the Central Range Cutter, has stated that the said fire officer had asked the authorities of the MCB Medical College to produce the building plan.
Approved building plan along with approval letters.
Along with the approval letter.
Issued by the competent.
Issued by the competent authority to him for further assessment. Mr. Mohanty, however, had not mentioned whether the said request has been complied with or not.
Now we have asked for that is the
asking for thing we know. Bureaucratic
whether they have replied or not, that is there. Yes, my lord.
No, sir. For that, I want to draw some kind of should be para annexure 3, my lord.
Yes.
That is very clear that they have not received any information.
That we have reflected.
That is what I am submitting.
Having considered the urgency addressed to this matter, we fix this matter again on 11th of September 2023. We cleared 3 weeks' time. All right. In the meanwhile, the opposite party shall come out with a comprehensive plan by which plan with the date by which this requirement, as asked in this petition, shall be complete stuff. We would expect that the bureaucratic rectopism will not come in the way, and this preparation of the proper design for the fire safety arrangement shall be made within a short while, and assessment and other thing also be prepared accordingly so that the comprehensive affidavit can be filed by the next day.
May I suggest one thing to your lordship? If your lordship will agree, your lordship may direct the RDC CD. He is the he will.
You are representing all of them. You are representing all of them.
No, it's only that is departments to and have a meeting and
Mr. Mohanty, just you call a meeting in your office of all the representative of the department, show the order of this court and the affidavits filed by the parties and ask them to do it first.
My lord, this order may be uploaded today, so that immediate step.
A copy of this order is supplied to Mr. Mohanty when it comes in the course of the day.
Yes.
All right.
Item 22.
Yes, Mr. Ross. Yes.
The sought issue here is about appointment of an Anganwadi worker.
Yes.
The appeal against me by the unsuccessful candidate went against me. I went before the
By the order dated, this is the order number 6, 5th of April 2023. This court asked you to produce a residence certificate.
documents. In fact, earlier we had filed, and today also one additional affidavit. But I am sorry, I could not.
Supply a copy to the learned
Copy has not been
because
I've received a copy of the additional affidavit.
This is right. It should be
Well, this is-
competent authority.
Well, this document, this certificate is dated 20th March of 2023. This is selection of 2010. There is that's on merits, my lord. I have to. I was supposed
It's
to.
all right, but you have received it. And
We have received the affidavit.
Okay.
And I am serving it on my learned
Instead, there is a very strange rule exists, Mr. Behra. Take care of this rule. It says the residence certificate shall be before the date of advertisement.
Your lordship.
Do you contemplate a thing that you do not know whether there is a vacancy when there will be advertisement? Someone will collect the residence certificate earlier, and I do not know what is the rationale behind that. If someone is residing, certificate says that he is living there for such and such years according to our information. But how the residence certificate is expected to be collected before the date of advertisement?
Your lordship is right.
I have already observed in a matter.
Your lordship is right.
If it is the last date of giving applications, one can understand. They can apply and get it. But if it's the date of the advertisement, how will they know?
Your lordship is right.
Unless they have some inside information which is totally
Your lordship is
not be
absolutely
done.
right. I have to stop. My lords, there is a difference between nativity and residence.
Exactly.
Nativity and residence are two different things. If my learned friend is, as my colleague has served a copy of my learned friend, if my learned friend agrees, I'll proceed with the hearing. Otherwise,
Yes. No, he says he has taken a
right. But if your lordship would kindly turn to
whether that against that vacancy any engagement has been made.
yes, ma'am, I am continuing since 2010.
You are still there.
Yes, I am still there.
Okay.
But I am still there. I am continuing since 2010.
No, Mr. Behra, you must tell us about what is about this affidavit and the documents filed. It shows that this lady is a resident of this area where this Anganwadi center is located.
My lord, there are two centers in this village. Center 1 and Center 2. The selection was made for Center 2.
Yes.
The appellant resides in Center 1. Her father-in-law's residence, her husband's residence is in Center 1.
Yes.
The impugn order records that the elder father-in-law's residence is in Center 2.
Yes.
And the appellant is relying on that residential address of her elder father-in-law's residence to claim that she resides in the Center 2. But her father-in-law's residence and her husband's residence are in Center 1.
Okay.
Now, yes, this submission is not backed by a single document. This submission that my elder father-in-law's house in Center number 1 is not backed by a single document.
No, Center number 2. He says
my elder father, it's regarding Center number 2. I have been appointed in respect of Center number 2.
Yes.
But as per the rules, if a lordship see Anganwadi guideline 2007, well, I'll just paste that one line. Can I just paste it, Lord? Only one line. Application for selection of volunteers to work as Anganwadi workers will be invited for each village Anganwadi center area from women residing in the said village / Anganwadi center area. Would your lordship kindly say this?
Okay, that was what I was thinking of.
Is anybody appearing for R6?
Well,
You were there. Okay.
Kindly see this guideline, ma'am.
Yes. Yes. So according to you, so
that is
in the same village.
No, I'll try to establish. I am the center area also. I am a resident of center area, not in the village. But the advertisement says that she must be a resident of center area. Kindly turn to page 14, man. Page 14. But this is in vernacular. I'll try just one
page
14 of my writ appeal, annexure 1. This document is not in dispute. That's their own document, my lord. And they have supplied us in 2000. Kindly see page 14.
Yes.
There is a survey report. Before issuing advertisement, they prepare a survey report. And they take survey of the persons who are residents of that center area. Am I clear, man?
Yes.
Now, this is the part of that survey report. You will actually see fourth from the top. 166. My husband's name is there. Viranchi. But
What's the serial number?
166, my lord. It is fourth from the top. It is vernacular. My lord, this what can see. Yes, yes.
It is
166.
66. There's a lot of
Overrating.
overwriting.
No. It's not dispute.
All right.
It's not in dispute, man.
All right.
166, it's not in dispute. Because this is their own survey report, on the basis of which I applied for and others also applied for. Now, Lord, I was selected on the basis of this survey report prepared by them.
All right.
Survey report prepared by them, if your lordship sees, page 18.
Just a minute. Viranchi Bag is who?
My husband.
Okay. So it says, two persons, you and your husband.
Right.
So 2 persons they say.
Right. Kindly see, this is the panel of selection. Huh. But for this center, my name figures at serial number 2.
All right.
And I have been selected pursuant to this panel.
Page 16.
What happened to serial number 1?
But serial number 1 is for different center.
Okay. For this center?
Page 16, Mr. Ratha.
Page 18, madam.
18.
What about this? 2. Lily Kumar.
The last.
But kindly see, the survey panel 2, serial number 1. Kindly see, Lord. This is whole panel is for serial number, center number 2. I'm sorry, Lord. Page 18, Lordship will see, serial number 1 is right last way. Belong to service area. At the this panel it is there. So she was disqualified.
Yes.
Lorships are getting that, Lord. Page 18 last, extremely last.
Yes.
Now, where is that? They do not belong to the service area.
Kindly see in handwriting,
This yeah.
it's already besides that.
Is it page 18 and 2, serial number 2, just after the total marks.
Yes.
Yes, this page, edition 2.
Page 18.
18.
Page 18 of my approval, annexure 2.
After the total
Oh,
marks,
on the
there is
right side is there.
Right side.
See in the picture. Yes.
Lordship's got it, ma'am.
Yes.
Right. Lordship, rightly see, I are seeing the serial number 1, Lily Kumar, she got rejected because she doesn't belong to service area. Now, so the second man is me, Padma Sinu Mehra. This I got selected because of my marks.
all right.
Now, I was appointed on the basis of that survey report is by them. I have not prepared.
Yes.
I was appointed till 19 months. It is appointment order. 8/4/2010.
Yes.
Sargipali 2, recent vernacular.
Yes.
Sargipali 2. So I got appointed on 8/4/2010. I continued, I joined. Now, Lord, thereafter the unsuccessful candidate.
8/4 you are appointed.
Right, Lord, 8/4/2010.
And you joined on the day?
Lord, we joined. We joined and we started working.
All right. That is annexure 2.
That is annexure 3, page 19.
Annexure 3, yes.
Annexure 2 is the panel, selection panel.
3 is the appointment letter.
3 is the appointment letter.
Engagement.
Right, engagement letter. Now, thereafter, the villagers are written that I am a receipt of that center area. No, that's not very relevant. Then your lordship sees the unsuccessful candidate, Sandhyavati Sahu, preferred an appeal against my engagement before the ADM. That is as per the guideline.
This is the respondent number 6.
Right. Respondent number
6,
my lord. Lordships are correct. 6.
And she filed an appeal.
She filed an appeal.
For the ADM.
challenging my engagement.
Yes, and by the order dated
By order dated 6th of July 2010,
the appellate authority cancelled your
set aside my appointment.
yes.
Lordship may kindly see the reasonings. Here there is a catch, I'll show your Lordship. Page 23.
Yes.
Lord, seventh line from the top on this issue. On this issue. Lordship got it.
Yes. Yes.
On this issue, the CDPO Bijapur.
Yes.
On this issue, the CDPO Bijapur has produced the survey map and location of the house of the respondent number 4 on 28/6/2010 in response to court's order dated 4/5/2010. The CDPO Bijapur expressed that respondent number 4, including her husband and father-in-law, are residing in the survey area of Anganwadi Center number 1 of Sargipalli,
Yes.
and they have no house of residence within the survey area of alleged Sargipalli Center number 2, for which the appointment has been challenged.
Yes.
Now, the CDPO in that appeal has produced a survey map which shows that I am a resident of center area number 1, not of the 2. Now, your Lordship may see, I'll just request your Lordship to see that survey again, that annexure 1. There is a reason why I am showing this. Page 14, your Lordship may kindly see. Page 14, your Lordship will kindly see.
I think this is not the same. This is only the report and that is the survey map.
Survey map has no existence at all. There is nothing called a survey map.
Okay.
It is only a survey report. And the report annexure 1, page 14, is in connection with center area number 2. That's the reason I am trying to tell your Lordship. Kindly see this, page 14 at the top. The number, Justice Rath can see it. It's written in Bangla, therefore I am requesting Justice Rath.
If you read it, I can also understand.
No, where is the
I will be translating it.
where is the DUI number?
Reading is not required. If you can read, I can understand.
Right. Kindly see Guru Karta ka name of the guardian of the house.
Yes.
Just above that, bill number. Lordship, get it. Bill number.
Where?
Lordship, see Guru number, Guru Karta ka number.
That oblique
Right.
slanting.
Guru Karta ka number, just above that, bill number. Meaning that it is for center area number 2. This survey prepared by the CDPO herself. For center area number 2, my name, my husband's name are serial number 166. Now, am I clear, madam?
That means the name of respondent number 6 should also be there. Where is it?
Respondent number 6.
Yes, because
Complete survey is not here. I have only filed a part of it. But that's not in dispute. She might be there. Madam.
it should be there because
That should be there.
166.
That should be there. That should be there. That I am not disputing. That should be there.
Oh.
But may kindly turn to page 17.
Your
17.
18 has
This very survey report, kindly see page 17. This very survey report, page 17 is the concluding part.
180 years.
Yes.
Dated 5th of March 2010.
Yes.
My lords, may kindly see at the bottom percent there is a blank space, nothing is written here. As you lordship can see it from this here. Kindly see, my lord.
Yes.
You kindly see from my, this portion is
Blank.
Now, during the appeal, CDPO filed the same survey report before the appellate authority. Kindly see that report. Page 31. Page 31. This is the report forming basis of cancelling my appointment. This is the report. Kindly see page 31.
Yes.
We are jointly karo signature Anganwadi worker 5/5/2010 Sargipalli. Then business government's note. I'll translate it. Let me read it in Odia. I'll translate it. Prakruta Biramchi Bali karo ghar number 1 survey achi. तार घरे दुईटा बाट रखी प्रकृत तार घर गाँ मिल पाखरे मीनिंग thereby let me translate it. Actually, the house of Biranchi Bagh as per survey 1 is there. Am I clear, madam?
Yes.
The meaning is Prakrutare. Actually, house of Biranchi Bagh as per survey number 1, which I have shown to you, is there. There are two.
One or two?
There are two doors in his house. Then he writes, again, actually, his house is existing at the end of the village. His house is existing near at the end of the village. This is what is reported. There is no reference to any survey map. There is no reference that I am a resident of center area number 1. There is no reference that I am a resident of center area number 2. This is what was reported. Again, kindly see, just below that, there is a tampering. Actually, it was written as 10/2010, it is tempered as 5.
All right, the report has come from them. All right.
Report has come from CDP of Vijaypur.
They are a habit of feelings.
That's right. But then, Lordship will see, what I am trying to emphasize here is, there is no reference of any survey map. There is no reference of my residence. There is nothing to show that my house is in center number 1, not center number 2. Am I clear, man? Now, based on this is the only document for the basis of the order passed by the ADM. Based on this ADM passes order, I do not know where ADM gets the survey map and other things. Now, I challenged ADM's order before the Honorable Single Judge. Honorable Single Judge, taking a cue from the ADM's order, has said that the report is there. Center number 2 and center number 1 is dismissed by report. If a Lordship would kindly see, under the RTI Act, they have also very recently supplied this very survey. The same survey report supplied to me under the RTI Act. I have given by virtue of that affidavit. Lordship will see, I have served a copy. The same survey report, there is no mention of anything in the same survey report. Can you see, madam? My today's affidavit, madam. That same survey report has been communicated to me by RTI Act 2016. And that is of 2010. That report is 2010. The same report is communicated to me in 2016. There is nothing about that remark.
Okay. Yes, Mr. Behra. It appears that there is no existence of any map. And your report is in favor of the appellant.
Yes.
Well, there is a distinction between this survey report and the one available at page 28.
Yes, what kind of a distinction?
That my learned senior has already shown.
That comment or something else? That comment or something else?
Lord, ultimately, the TDPO has reported.
But why should a comment be there in a survey map when you given the names in the in the list? Why should an extra comment be there unless it has been asked for?
Now, even if there is a comment, you have to look into whether the comment is based on the information during the survey has been collected or not. Suppose I collect X information, I say, no, this is the Y information. Well, the court will go by this kind of a survey comment or not. And we look for the more reliable documents so far the residency is concerned.
If your lordship may permit me, I will produce a map.
No.
Let the authorities produce a map.
Because of the location of that house.
Of the house. Yes. That will clear everything.
Actually, that is there in the border. That's the problem.
That we have seen in the border.
One is Sarvati 1 and
that's must go to the appellate.
So that's why
that is the position of the benefit must go to the
which door they use.
Actually, for the other one petition, that is the reason.
the particular village, maybe the other part of this house also fall on the other side of the village. That doesn't matter. And moreover, what is striking us most is the provision of the your own rule. It says the village, not this residents in a particular service area, both can be considered.
Yes. But the advertisement says there has to be a Sthayi Basinda. Is the word.
Settled residents of that particular area.
This is not in controversy this time. Only controversy is that the resident is not in the service area. That is the whole concept of controversy.
And it is at the door.
Yes.
Confusion with regard to doors, 2 doors.
And from 2010, I'm working. This lady is working now in 2013. Does it look nice? On this ground, insignificant grounds, you destabilize someone.
I working in the entry order.
So you work with the entry order. We think nothing more to be inquired into.
If Lordship permit that map, if the state comes, state
map is not filed before the appellate authority on
map is not there. If
it is not there because they have tried also by. If it was not there, how this finding can be?
Finding on basis of the CDPO's report.
That is why she is reading a map that is non-existent.
Non-existent map, but there is a report of the CDPO on which basis the ADM has passed this order and Honorable Single Judge has passed this order. So I will pray that state may produce the map so that it can clear. That's the only thing.
Because this, because whether
this late appellant is coming
not in a Article 226 proceeding.
Yes,
neither will record fresh evidence when it is virtually comes from an appellate authority's order. We have to think only whether the process was followed properly or the order that has been given it suffers from any such defect.
Yes,
that it requires our intervention. Simply these are two grounds which is simply.
It's
a writ appeal, no.
Yes.
Order has been passed.
Only that map can solve all, whatever the controversies.
That will be the inviting new evidence. Yes. It's not true. We'll see whether the order passed by the appellate authority is correct and there was the material before him.
Yes.
The material showed by the appellate is clear that that was completely on a different premises the order has been passed. Mr. Behra, that we are.
I leave it to you, Lordship.
Closing the matter.
That's it. Grateful.
Thank you. Yes. But Mr. P.K. Rock and the Senate Council, assisted by Mr. Jain Sahul and Council of the Appellant, also heard Mr. A. Behra, Appellant Council appearing for the but it has to be done today. Mr. A. Behra and Council appears for the respondents number 1 to 5. And your name, sir?
My name is Mr. Panda, Jagjit Panda, on behalf of Mr. Sukumar Ghosh.
Mr. Sajinsaj, appearing on instruction of Mr. Sajinsaj for the respondent number 6. We will be passing because my sister is suggesting that there are a lot of matters that waiting. We are just giving this operative part of the order now.
That's right. That's
in our considered view, both the appellate order dated 6/7/2010 and the order dated 19/7/2016 passed by the single judge in WPC number 12438 of 2010 suffers from consideration of materials which are not borne in record and non-consideration of the materials, those are already on record. According to us, the appellant has been able to fulfill the requirement of the revised guidelines for selection with the Anganwadi workers, which provides that for selection of volunteers to work as Anganwadi workers, the said Anganwadi worker shall be the resident of the said village / Anganwadi central area. Stop. Mr. Stop. In view of the survey report dated 4/3/2010 relating to Anganwadi Center number 2, annexure 1 to the Memorandum of Appeal, and the joint petition. What is that joint petition?
Joint petition is by the villagers, my lord. Not by
The other you are showing?
Joining report.
Joining report. No, appointment order.
No, the other survey report that was.
Achha, that is the survey, the same survey report.
D by 6.
During the March.
All right.
Annexure D by 6,
Sure.
along with the endorsement of the CDPO.
Yes. In the result, this appeal stand is allowed. We set aside both the orders dated 6/7/2010 and 19/7/2016. Stuff. The petitioner shall be allowed to continue as a member of the worker if she is disengaged by virtue of acquiring the age of superannuation or for any other reason. Yes. But not on the ground of residence.
Right. Grateful.
All right. Mr. Where is Mr. Speaker? Yes. We are keeping your book for a while. Your book will be returned in the afternoon.
All right. Tomorrow, day after.
62 years. 62, sir.
Yes.
May I please, Your Lordship? Your Lordship, I am for the petitioner. Your Lordship.
Date
Yes, 62.
This is a matter of Lordship. The petitioners are the villagers of Jagannathpur. Your Lordship challenging the Annex of 5, that is the closure notice of the public road, Your Lordship. This is the notice which has been issued by the NTPC. Your Lordship, kindly have a glance to the Annex of 3, Your Lordship. Page 22.
The 2nd November notice.
Pardon, Your Lordship?
2nd November 22 notice.
Yes, Your Lordship. Your Lordship, in that public notice, Your Lordship, kindly have a glance. It is to inform all the public that construction work of NTPC TTPP, expansion of TTPP has already started. Some major facilities of the new plant are going to be constructed over the road connecting Jagannathpur Anand Bazar through TTPP, for which the road shall be closed with effect from 15/11/2022. Accordingly, passerby are advised to requested to use Jagannathpur Anand Bazar bypass road for transportation. Your Lordship, NTPC is the leaseholder, Your Lordship.
Yes.
And they have no right to issue such public notice, Your Lordship. And Your Lordship, kindly have a glance to the ROR, Your Lordship.
This is a public road.
Yes, Your Lordship. This is a public road. Your Lordship, kindly have a glance to the Annex of 1, Your Lordship.
Yes, who is appearing to the state?
Yes, my lord, I am appearing for this.
What is it?
I am appearing for NTPC, my lords. And my lords, what we say is that we are not the owners, my lords. By a statute, we have become the owners. This was under OSCB, my lords, and later on, my lords, by statute, the lands were transferred to us by the state government, and we are the owners of the land.
Also, the length of this road.
My lord, there is no public road.
Contradiction, this is a public road.
No, there is no. It's a public.
Sub-collector's report by order of this honorable.
Yes, sir. I have a glance to the.
Just wait, let him explain the things.
Yes.
What is the sub-collector's report?
That is, I have filed along with the affidavit.
This is a culture sub-collector?
Yes, my lord. 16th June 2023.
This has been made after the direction of this honorable.
He is only stating that by order of this.
By order of this honorable court, there was a meeting. These petitioners and the authority of TTPS NTPC and local representatives. And we wanted to solve this issue. This is no way prejudicial to the interest of any general public. This road is inside the plant campus, and now a road is being provided which is in a better place and suitable location, and this authority, they will take this road, this
inside the project area.
Yes.
It is within
the project area, my lord.
It is within the project. And for the safety purpose of the people, rather it is better, the alternative passage is much better than the existing so-called passage.
My lord, if your lordship takes page 111 of the NTPC council, I have provided the map with the current road, the bypass.
Whether the petitioner has got the copy of the map?
Yes, yes.
Yes, it's annexed to the counter.
This annexure 1/3. This
K by 3.
K by 3.
K by 3 at page 111 of your lordship.
Annexure I by 3 is one map.
My lord, lordship will take K by 3.
K by 3 indicates the relative positions of both the roads, my lords.
Okay.
My lords, your lordship sees your lordship gets K by 3.
Yes, yes.
Your lordship sees these dotted lines.
Yes.
This is within the NTPC area, which has been transferred to us by a statute, my lords. But the state government has transferred these lands to us, and this is the road within the NTPC area. My lord, some members of the, because trucks pass in and out, some members of the public were utilizing these roads. It's not a notified public road.
No, it is a shortcut for them.
For example, my lords, people utilize this passage to go to the collectorate. Does it become a public road, my lords? It utilizes the path within our High Court to go to the collectorate. It's not a public road. It's within the premises of the High Court. Now your lordship sees the red marked area which we have now built up a concrete road, provided lighting, and we are also utilizing the same road, my lords. It starts from that point, same point, and it goes right around the boundary. And there is another 1.15 or 1.5 kilometers difference extra. Well, this is and we are also utilizing all assets, and the facade of the entire industry will be facade of the entire industry will be in this on this road, my lord.
No, it has been admitted that that was a revenue road which had not been closed for the convenience of these people.
Yes, my lord. It was acquired, and your lordship may kindly see the statute
of my report. What's a reporter?
Report. And your lordship will see the statute.
Internal page 4 of my report. That is this, how they become the owner, that is also reflected in my sub-collector's report. Internal page 4, annexure A to my affidavit. Page 4.
This sub-collector's report?
Yes, my lord. Sub-collector's report, annexure is affidavit, annexure page 4, para 5 and 6.
You are referring to transfer.
That in exercise of the power conferred by subsection 1 of section 5 of the Talcher Thermal Power Station Acquisition so-and-so Act, the state government had specified the 3rd June so-and-so as the date on which the TTPS based in the NTPC free from all right notification number so-and-so, that there was no term. So this land and para 4 that the power station so vested, this land was vested on TTPS. Then again vested to NTPC. So these are their land. But what my lord is saying, for convenience, people are using this road for some years together. There is no dispute in it. But it is their land, and within the plant area, that is why they have closed it, and alternative passage has been planned out.
The state that
That is a bypass, only 1 or some kilometer.
And we closed it with the permission of the state government. Well, Lordship, can kindly see page 126, the permission of the sub-collector Talcher.
126.
126. Annexure M/3. Lordship gets it?
Yes.
With reference to the letter on the subject cited above, this is, my lord, subject closure of road inside the premises of NTPC TTPS. Your letter dated 18/10/22. With reference to the letter on the subject cited above, I am to say that permission has been accorded in favor of AGM HR NTPC TTPS Talche to close the road inside the premises of NTPC TTPS with a condition that there should be adequate publicity in nearby areas and there must be a suitable alternative road, which we are given. Now, my lords, I will also explain why we are closing the road. My lords, this entire premises, I've given the statute, my lords. I'll read out the relevant provisions of the statute. My lords, our plant was 440 megawatts of producing 440 megawatts of power.
It is thermal power.
Thermal power. Now what has happened, my lords? Both the state government and the central government have directed us.
Closed down.
This was closed down, my lords, by a closure report which was accepted, and there is no retrenchment. Everyone is waiting, my lords, for the plant to restart. 440 megawatts generation has been now increased to 13 megawatts.
That's sufficiently argued. Yes, Mr. Counsel for the petition.
Your Lordship,
Now, first kindly consider.
Yes, sir.
When is a power generation plant?
Yes, Your Lordship.
Is in the national interest some road should allowed be to through this power plant or not?
Unsafe.
There is a national security issue involved in that.
Yes. Your Lordship, there may be change in the plan, Your Lordship, but the road, Your Lordship, kindly have a glance to the ROR, Your Lordship. That is the status of the land is, Your Lordship, that is road, Your Lordship. Kindly have a glance, Your Lordship. That is plot number 30, Your Lordship, which we are disputing, Your Lordship.
The road and public road, is there no difference?
Yes, Your Lordship, that is a public road. Your Lordship, that is a public road. Your Lordship, kindly have a glance to the ROR, Your Lordship.
ROR.
No. While that land was acquired, was that public road excluded?
No.
Let it.
Yes, Your Lordship, as per the lease principle, Your Lordship, that is which was been made under 1/1970, as per the lease principle, that is 28/12/1962. It must have been made under such principle. Your Lordship, kindly have a glance.
Must have been.
But if you get the alternative, this access, what is the problem in that?
Your Lordship, we have to cover the distance of 5 kilometers, Your Lordship.
No. 1.8 kilometers, my lords.
1.8 kilometers. This is a bypass.
Your Lordship,
So
kindly have a
that
glance to
is land.
Let's see. Otherwise, they would have gone directly. Now they have so they have to cover a lot of space.
Your Lordship, that is
For
bypass.
that inconvenience, they have come to this board.
Your Lordship knows that nowadays everywhere we are going to bypass. In Pipili also there is a bypass, and this
So why
area.
should they give up without a fight?
Your Lordship, the station is that they approach directly through that road to the station, Your Lordship. It is straight away road, Your
No,
Lordship.
we understand, but it is for your own safety. And my brother stated for national security as well as safety. If some accident occurs,
We are not against the power plant, Your Lordship, but only that road is existing prior to.
you have to go through the power plant. That is the problem.
But there can be change in the plan, Your Lordship.
Unsafe.
Your Lordship, kindly have a glance to the lease principle, Your Lordship.
Yes, wait.
That is page 25, Your Lordship. I have given copies.
Yes.
In page 25, Your Lordship, second paragraph.
Yes.
The existing and customary rights of government and the public. The existing and customary rights of government and the public in roads and paths and rivers, streams and channels running through or bounding the land are reserved and are in no way affected by the lease. Your Lordship. This is the lease principle which has been.
Principle has gone, now the act has come.
Your Lordship, that lease has been made, must have been made by 1962 because in 1976 there is another principle for industrial lease, Your Lordship, which is more favorable to us, Your Lordship.
What about this act? What about this act, section 5 of this act?
The entire land has been transferred to us.
No, this already, here,
Yes.
so he has reached a point on the basis of certain principles.
Your Lordship, using that road is a, Your Lordship, the public rights, Your Lordship, the fundamental rights of the villagers, Your Lordship, right to access the public road, Your Lordship, this is the fundamental right of Your Lordship villagers.
We are not getting any document. Someone is a road, also the English translation of the path. That is the traditionally we use this or someone translated the road. But the public road in this record of right principles,
yes,
this occupies a very specific connotation. This is a public road used for the public. Can we show any document? Road will not do. I am telling you very carefully on this.
Your Lordship, the status of the road, that status of the land is road, Your Lordship.
Because we have the report of the sub-collector.
Yes, if on basing upon that affidavit, Your Lordship, kindly have a glance.
Yeah, just show from the affidavit that somewhere he said it is a public road.
Point 6 and 7 of the sub-collector, Your Lordship.
He has come to that.
There was no Lordship.
Yes, got it.
There was no term and condition during transfer of ownership of the land from the state government that the road would remain as it was.
Yes.
The NTPC was liberty to use the land as per its suitability. Your Lordship, then point number 7, Your Lordship, that the notice for closure of road was given after getting consent. Your Lordship, if they can use it as per their suitability, then what is the need of the consent of the government, Your Lordship? If they are the owner of the land, it is because they are the lease, they are the lease and the government is the owner of the land.
Because there is a law that is
Sub-collector is the law and order authority.
because this is because when in a traditional pathway even, the public doesn't have any right to claim it a public road, but it was in fact existing in the reality. These people are using that road, but suddenly this will be closed. There may be the public clamor, and that is the reason they have taken the government permission that we are closing it.
Your Lordship, before the lease, Your Lordship, that was remain road, Your Lordship, because from the ROR it clearly shows, Your Lordship.
I am asking you, learned counsel, time and again, there is a difference between the road and a public road. As Mr. Kanongu was showing us, there is a road connecting the revenue office here. People are using that. Can you say this is a public road? All the principles will apply when it is declared as a public road.
And the record of right itself stands in favor of the NTPC. That at Annexure 1 at page 13.
It is open to the name of the
NTPC is the paramount owner.
Ah.
And he is showing the remark column road. But owner is NTPC. So that road is presumed to be the NTPC's road, who is the recorded owner of the land.
No, that is why I am pointing out that if it was a public road, the entire road's plot number would not have been recorded in the name of the NTPC. That would be a separate record of right for the public road. That is the generally principle followed in all over the country. I do not know whether there is any deviation in the Orissa rules. I don't know that. But usually that happens because the owner claim, as Mr. Mohanty says, it is a paramount owner. We call it as owner in possession.
So for that reason, I cannot dispute on that The only thing
That
is
what
that
has been protected under the list principle that you have seen. This is a new idea. I appreciate that you effort. But this is only respect of the public road, not the usual roads running through the complex and other things. Then the government cannot utilize. No, there is an issue of fragmentation. Just be visualize. As a citizen of this country, because you are in a public interest litigation. Everybody is now supporting to have a conciliated settlement over that issue. That they would need the entire premises, they are needing the thermal power generation. This is a very restricted area. I don't know whether have you visited everywhere in the country. You cannot even enter into the premises without your identity, permission to enter. You cannot.
And they have those guards with those towers.
I'm telling you, as a judge, I visited the Vakran as well, the power generating program for the hydel power generating program. I was just searched for 3 times. I did not oppose, but I cannot oppose it. Because it's such a security perception is there. Because it is stealing in a very close to a country which is not very favorable to us and doesn't favor us. So I allowed that to happen because I will go down below the river.
Your Lordship, what I humbly submit.
That is the perception I am telling you.
Yes, Your Lordship.
I understand the difficulties suddenly that people started facing it. They have right to resent, but we have to give the privacy to the greater public interest. And power is one important sector.
We are not against that.
I understand. You take a 1 extra mile addition to serve the interest of the country. That will be our advice. Tell your clients to do that because it will be very risksome. Sometimes when the certain thing happens very adverse to the state, the targets are very soft. Power plants are one of the targets. The plants are the targets. So that it will create a disruption in the public life and order. That is also security measures are taken. I understand, that is the security measures only. If it is an ordinary office complex, government is a popular government, usually doesn't take such step.
Your Lordship, what I humbly submit.
I understand that. Got your point.
And the sub-collector has also reported that these petitioners, they don't oppose the establishment or development of.
That is what he's saying. It is
So
Mr. Modi, their prayer is very limited.
Correct.
If it was not even the power plant and some other things, I should say that you have constructed both the sides of the road once so that they cannot have the entry in that much, they will go through it. But problem is the power plant.
Safety and security.
You have alternate.
May I submit, Your Lordship? The Honorable MLA and MP was present in that meeting. What is their suggestion, Your Lordship? Kindly glance, Your Lordship.
That is a very difficult to just go through this.
Your Lordship.
We can understand.
In page number 5 of their affidavit, Your Lordship.
Which affidavit?
Submitted by the state, Your Lordship.
Of the record, I would like to submit. The people representative will say in favor of the majority. So, your Lordship is to examine the reality.
The voice of the public representative will not.
I don't find that there is a separate affidavit from the state. Only this affidavit filed by the collector.
No, only this.
Which
Only
page?
this record.
Mr. Jenna, which page do you want us to see? Where?
Page 5, Your Lordship, of their affidavit.
Whose affidavit? 3 and 4?
1 and 2.
1 and 2 is additional affidavit.
Yes, Your Lordship.
Report ta koucha.
OP na petitioner ka katha कहउजंदी OP
Sub collector जोटा affidavit ଦେଇଛନ୍ତି.
Sub collector ko report.
Sub collector affidavit. Okay.
Page 5 पे.
Honorable MP.
The Honorable, may I submit, Your Lordship?
MP Dhankana suggested.
The Honorable MP Taicher and the Honorable MP Dhankana present in the meeting held the stand taken by the petitioners for not opposing the construction of the new power plant.
Yes.
However, they stressed that the NTPC authorities should take the views of the local villagers seriously with regard to repair, renovation and maintenance of the connecting roads. Both of them stressed that the road along the conveyor belt towards Ghantapada, NSCH, Bolanda and from Jagannathpur Bazaar to Bampel Railway Gate. This is the road, that is the plot number 30, Your Lordship. No. Are in dilapidated condition and NTPC had been silent on repair, renovation or maintenance of the said roads for which general public of the locality are facing difficulties in commuting daily and in transporting the materials on the said roads. They suggested that the NTPC authority must take immediate steps to repair the above mentioned connecting roads to ease the plight of the local villagers. The Honorable MP suggested to explore the possibility of change in the design of the new plant that to allow for a road inside the plant area for convenience of the local people.
Possible.
This is the suggestion which has been given by the Honorable MP, Your Lordship, that cannot be sidelined by the government, Your Lordship.
But page 4, the Sarpanch has suggested, so that road, is it a separate road or what? They stated that though part of the alternate road, Jagannathpur bypass road was available and widened by NTPC.
In using the alternate road, if at all, the existing road passing.
We were showing which goes across the boundary, which is 1.8 kilometers. We have certainly concretized it. There are lighting given by us. Cameras are there on the way for public safety. Everything has been done by us. That is the alternate road, which my friend says is another 1.8 kilometers extra. That started in 62. Now, since we are in an era where terrorism is a very practical factor, Malak. So 62, it was a bit relaxed.
440 has become 1320.
And 440 has become 1320 megawatts land. And it is on the same land. There is no fresh acquisition. So we have to build our entire factory on this parcel of land. From 440, it has been expanded to 1320. So obviously, facade and face of the plant also has changed. All our quarters have been broken. This road has been broken. We are also going to utilize this road. This will be utilized for the extended project. Because it's now 1320. It's no longer 440.
So that Jagannathpur bypass road is the alternate road you are giving?
Yes, page 6 of the report. On the issue of safety and security in the alternate road connecting to Talcher Thermal Railway Station with the Kali Mandir Chowk.
That portion was in a state of disrepair. You are saying it has been repaired.
That also, Lordship can direct them to.
No, that is revenue road. That's state.
They are also asking for repairs of the revenue road, which is of
which is outside NTPC,
which is totally outside our area.
So that state government.
State government.
Because they are saying if you give an alternate road and a lot of security concerns are there, they are saying snatching and everything was going on.
Patrolling is going on regularly out there. We have cameras installed. Lighting we have done.
These are not the issues is very material for determining. Their issue is the shortest possible the access to the sides of the. This is the
which they are using much prior to the establishment of the NTPC, which has been in use much prior to the establishment of the NTPC. And that is my humble submission also.
Opposing the construction of the project in that area. But there needs a contiguous area, not the disrupted and segmented and
deeply. We need a contiguous area.
Safety and convenience.
Lordship, what I humbly suggest to Lordship, the Lordship may direct to appoint an expert committee to whether that plan can be changed or not, Your Lordship.
No, sir.
Don't know the expenses that will come.
You are not getting our point also. If they are not opening up an alternative road, then we understand. All that we'll carefully go through all your records again and we'll pass the order. It is not CAB, we'll pass the order. Physical records which is it is disposed of. My lords, but I appreciate the way you have presented the case, Mr. Jena. But sometimes
Abhinav Swai, Your Lordship.
Yes, Abhinav
Swai.
Abhinav Swai.
You are taking adjournments. You are saying, Mr. Jena, you are not objecting, and today you are giving. I said, when you take adjournments, you mention the name of Mr. Jena, you don't object.
No, Lordship, I have mentioned my name.
Citing your name as Mr. S.P. Jena.
Abhinav Swine.
So okay.
My lords, I have just a single prayer, my lords. My lords, what is happening? The PIL has been filed by the Sarpanch, and my lords, the husband, they're creating a lot of ruckus. So I just want an observation for your lordships that the state government may cooperate, give adequate police force for us to go on with our construction work. Otherwise, a lot of hurdles are being created.
That you
It is duty if the public interest litigation is disposed of. We did not mention it because already there is a public patient.
If there is any law and order situation, naturally they will contact the
132 for power.
130.
They need
But also they are
in action.
Also created action when the state government is helping us out. We don't want to get into that. One simple observation of the lordships and they will, because the local authorities, they are, my lords, getting rattled by this. They are saying the matter is sub judice. So we will
the direction of this honorable court. Where is the petition of
petition of consent is actually creating all this nuisance. We have filed an FIR.
So after the judgment, everything, if the person is passing the final judgment, thereafter everything will be settled. Whatever direction your lordship will issue.
That is why I'm just praying for a simple observation that the state government.
That is will be out of the context.
That is true. It is out of the context.
Lordship only observe that the safety measures and the road, the condition of the road may be improved. Lordship. Yes, Lordship.
Of the alternative road.
Yes, Lordship.
That definitely will do.
It's already done. It's already done.
And safety, so far as safety and security is concerned.
Always. That will do.
Deeply obliged.
This Mr. Marti, the security concerns will be on you.
Yes.
And the safety and the repair of the road will be the NTPC.
Yes. Whatever direction your lordship.
It will be perennial direction. Not that the one side we have done. No. Do that. It will be perennial direction. Well, so the commuters, the pedestrian doesn't face any difficulty.
After completion of the plant, we will be utilizing this road.
Charge of its this repair and other thing. This is a very short road.
My lord,
more than 1 kilometer.
May I submit one thing? Once this road is constructed, there will be this land adjacent to the loan. That those lands will be costly land, and everybody will have their commercial place and residential area there. So after 1 year, again that will be a the very popular.
Are you saying again you'll acquire that? Again they will.
That is not. But that road will again.
Because citizens, a patient must be that we will take care of the road. So that is always.
Yes, fellow, we will take care of the road.
Security part is direct on the government, and the maintenance of the road will be the NTPC.
Certainly, much. Deeply obliged, man.
Matter to be called 1231.
Item 56. And the short question in this appeal, while dismissing and giving sufficient reasons for the dismissal of review petition, has any competence or jurisdiction to pass an observation which occurred at page 44. Lordship will kindly see the improved order.
Yes.
I have extensively quoted all his reasonings. Everything is correct except that stray observation at page 44. Lordship will kindly see a para number. I'm reading out. Page 44 of the impugned judgment.
You are challenging a judgment of the review petition?
Yes. Review petition is dismissed in favor of me. But that observation, he is taking advantage of that and filing one appeal after another after 6 years. When the statute provided 60 days and another 60 days for filing appeal, they did not file an appeal. The appeal number 1, employer, before the competent appeal authority under section 7, subsection 7 of the PG Act,
the award is passed in 17. What they prefer? They prefer a review. And review was dismissed. They did not prefer appeal. And I applied to the CG
comes to the judgment.
Page 23 to 44 is the judgment passed in review petition.
Internal page of the judgment we are going to.
That is 18. That is internal page is 18. Page 18 para. Let's put one para. In C1.
Page 18.
Page 18. Read up in page 42.
Yes.
But you kindly see at the 7th line. However, you got it. If the review petitioner is so advised, he may assert the order passed by the concluding authority in an independent proceeding lodged at that instances.
Yes.
This is without jurisdiction. And taking advantage that, he has filed one appeal before the
controlling authority.
Where?
Controlling authority.
Controlling authority has passed the award. He had an opportunity, he had a right, statutory right to file an appeal. Did not prefer appeal. Therefore, and thereafter, I filed a writ petition WPC 18066 of 2017 for directing the controlling authority to proceed with a form T application for recovery of gratuity. And during the pendency of the writ petition, they issued a SOGO to employer. And in the meantime, on 4/9/17, Honorable Single Judge directed the controlling authority to proceed with the application and complete it within 2 months from the date of the order. They challenge that in review petition number.
What is the 4/9 order?
Yeah.
4/9, it is in which year order?
That is in WPC 18066 of the 17. That was shortly reviewed by the employer in review petition 233/2017. And that was rightly dismissed by the Honorable Single Judge. Except that sentence, that observation that they mean it as a liberty. Court cannot go beyond the Honorable Single Judge cannot go beyond the statutory limitation period. And the review petition was aimed at that order. Review of order dated 4/9/17 passed by the then Single Judge, Honorable Single Judge in 18066/17. And that having been not, the review of that order having not been acceded to, no further right, I would humbly submit authority or jurisdiction invest with the Honorable Reviewing Judge to pass any other order. Stated High Court in all the previous pages, rightly observed that it was void, incompetent, not maintainable. How can this observation can be passed? What are the authority of the Honorable Single Judge reviewing the decision of another appointment bench? And also, I try to explain that this portion because after the dismissal review petition on 28/3, when I got the petition filed by the employer against that PGA authority's order, they said that we have filed an appeal before the Joint Commissioner, Deputy Level Commissioner Jajpur. So in Utah, they withdrew that petition, their own petition. Thereupon I came to know that such a portion, which is not an observation, I did not take it seriously. It is not a liberty. No liberty can be granted in any petition which is dismissed. And after 7 years, I have been waiting for 9 years to get my portion of that part. After the PG authority awarded, on 6/17, by some means, by approaching some wrong forum, not the proper forum, they have been doing the process.
You are appearing for the employee.
Yes, employee. I am the employee. I have retired from 2031/5/2014 and nearing 70 years.
So you are agreed only by the observation in the written.
I try to expose it, get it exposed by the honorable single judge of the party review decision, decision. He said he has altered position.
Also,
what permitted him to alter position?
The rules are there. Payment of gratuity rules.
Section 7.7.
What is the rules is there? Find out the rules. The central rules. This is the payment of gratuity.
And also, Orissa rules have been discussed by the judge. It was not an expert order.
Who is appearing for the employer?
I am there.
How after the gratuity is determined, these provisions of section 10 and 11 can be invoked.
Section 10 and 11
of the payment of gratuity act, the central rules. Rules.
Rule 11.
Yes, rule 10 and 11.
Lordship, I'll briefly place the background. Here what had happened is the employee retired in the year 2014.
It's all right, but there is no dispute. The payment of gratuity has been determined. No,
not fit. No, that is a dispute, Your Lordship.
No. This Learned Civil Judge says it is determined.
It is determined. Yes,
given you the liberty to approach the appropriate authority,
Lordship.
So against the determination of the amount of the gratuity, you have no grievance.
No, Lordship. I have approached under section 7, subclause 7 appeal.
No, after the review petition observation.
No, this review petition says that the amount is determined already.
The amount is determined by the controlling authority, that is under section 7, subclause 4. And subclause 7 provides for appeal against an order of determination made by the controlling authority under subsection
yes, 4. That is there.
He has not filed.
So under that 7.7, I have preferred an appeal immediately after disposal of the review application.
That can be so.
No, just these. Have you deposited the money before the?
Yes, Your Lordship. I have deposited.
Controlling authority?
Yes, Your Lordship. Amount is deposited. Accordingly, the appeal has been entertained.
Without noticing me, without any delay, because the delay is of 7 years.
When you filed the appeal?
Your Lordship, initially the appeal was filed on 16th March at Jajpur. As the
16th March of 2023.
There the appellate authority post was vacant and the controlling authority was in charge of the appellate authority. So he returned the appeal. Accordingly, the appeal was refiled at headquarters on 15/5/2023.
Without taking any leave of the sum report.
No, this is all right.
And thereafter, I made the entire amount before the controlling authority at Jajpur. After a deposit of the entire amount, the appellate authority has admitted the appeal
issued notice and he has also rendered appearance and filed his objection on 5th August.
Yes. Now the one question that on the basis of that order of the review passed by the learned civil judge, they have already taken an action, there is a appeal, and you participated.
No. Once
he filed the objection.
He has appeared on August 5th only.
I have prayed for recovery of the order admitted appeal because there are no notice to me regarding counsel delay, and also I filed a miscase before the lawsuits for stayed that proceeding, but that is non-list. The Honorable Court in the order dated 11/4/2007 granted 2 months time. Does it not know that the DLC is the in charge of the
leave has been granted?
He has not taken leave to file with the second appeal because he had filed a wrong appeal. The entire history of the case will show that he has been appealing wrong forms deliberately to deny the benefits of the author out of the other. Although he did not file the appeal at that time, he filed a writ petition. Once I got a direction of the Supreme Court, which was sought to review to proceed with the from the proceedings,
the amount is only 2,57,768.
That was at the show stage. That interest is accruing on that.
According to what you understand.
Madam, I would only pray after the adjudication, honorable review judge has stated on perusal of the other passed by the Honorable Authority, it is this code plus that page, that para.
At what page?
That page 42, page 21. After that observation, however that is out, he would find appeal. Honorable Sir, I have gone forward and ahead on perusal of the other passed by the Honorable Authority, this code upon careful observation of the inside is of the considered view that the representative of the management was hard and his submission was taken into consideration by the Honorable Authority while passing the order. Therefore, the order dated 6/4/17 is an order passed by the Honorable Authority by exercising power of Rule 11(4) on perusal of the schedule. It appears that the scope of review has been provided. He also reviewed that order, tried to review. Provided under 11, which
you just read this line. Therefore, this court is of the considered view, the controlling authority by holding that he doesn't have the power of review against the order passed by him is not erroneous and illegal. What this sentence mean?
That will clear approach for review.
At that time, the management.
What is the meaning of this sentence? Read out. The page 18 and 19. Therefore, this court is of the considered view.
That para last word one para word.
Yes, come to the page 18. The last two lines I am looking.
Last two lines. Therefore, this court of the personal view where the control authority while exercising.
No, while holding that.
So by holding that, he doesn't have power over. Is not erroneous and illegal.
All right.
That also is not to the context because the Honorable Civil Judge was called upon to review if that order, in order, to directing the form to be submitted to be considered 2 months from that date, 4/9/17. What lies in review? Rightly, to say it is dismissed.
Understand what perspective of this observation? Because it was before the learned single judge earlier.
Yeah. What was that? That's to deny. That's to deny because the review has failed. The review has been dismissed.
No, just wait. The before controlling authority on review application was filed by the employer.
Yes, that was dismissed.
controlling authority who held that I do not have any jurisdiction to review my own order also because the law doesn't permit. They came to the learned single judge?
No, they didn't come. I came.
Why?
Because I represented, I told the authority to proceed because there was no appeal. At that time, from 6/4 to 5/4/17, 5/8, were the time 60 days and no 60 days under section 7, rule 7 of the PGR.
Yes.
To proceed with the appeal. They did not. Within the extended 2 months, we
did approach the High Court.
The High Court to expedite my application for recovery of gratuity. I find the controlling authority did not proceed with that. The Honorable Single Judge directed to complete in 2 months that 2,05,000 should be that's so costed.
All right. Then have you filed any contempt proceeding?
He cannot review this review.
This is dismissed.
This same single judge admitted the review and put it, called it with the employer's writ petition 202617. That the challenge that award would be with order 227 to 27.
Just show me the first controlling officer authority's order, which they intended to review. What is their order?
That is not right now with me because I have only prayed simply that expulsion of that because that is not a liberty or a statutory right of appeal.
Just wait, learned counsel. Then you are challenging a part. What is that? Can you show us this first authority? They already paid you 10 lakhs.
Yes, but beyond that, under 4.5, you should go through that award. I am entitled more because I am governed by the MSS agreement and the same gratuity they have been closed. It is same unit. Taken over in 94 and state government. Now also it has been purchased by Tata Group company. When the state government could not manage. But they did not, they filed a reply. They said that it was expiry order. Challenged it and sought review of the order directing.
Now they have filed the appeal.
Yeah. Now it will be in taking for some years. Thereafter they will come to dishonorable court. Any party agrees.
Because
they are now raking of all issues for 6 years.
No, this whole
that was the deal because in view of the judgment of the on Supreme Court, this advocacy, I filed 4 appellations. But there is no interim or stay.
All right. Just consider the spectrum of the case.
Yes.
Because we have to consider this. When a single judge is passed, any other remedy they can pursue it. Despite this.
No, file an approval proceeding.
That is why any other remedy
that like the Supreme Court. Not
some patient to hear us also. We are patiently hearing you so long.
No, I'm sorry.
Yes.
I apologize. So.
Yes. So the statute itself provides an appellate provision, right?
Yes.
But you approached this court for expeditious execution of the order of the controlling authority.
Yes, after 5 months of the order.
Or whatever. Don't bring this. Then the court passed the order They wanted a review of that order. And this is the review order, now you are challenging before us.
That's only
regarding this remark.
Yes, remark.
Suppose these remarks are not there. Forget, we expunge this remark.
Right.
What will be the consequence?
I am entitled to payment of that.
Can we abrogate their right to file an appeal?
At this stage. At this stage.
Whatever stage, can we abrogate that power? The appellate authority will determine whether they will sustain the appeal or not. Then the court can do that. No, you have no right to file an appeal.
Well, because statute, there is a bar of limitation.
That you argue before the appellate authority.
Yes. That we have not given notice. We have not given notice to the.
You go there and raise a question relating to the maintainability.
Yes. I have filed a petition.
Ultimately, that meltdown to that point, court has to declare that their right to appeal is now abrogating.
No, within the parameters of the
I understand your urgency and necessity, but the law will take its own course.
Yes, law requires me, Lord. When you review judgment,
we abrogate.
Yes,
you abrogate this opposition. That will not.
I will high mobilize. You have to do.
You abrogate. They cannot. Because you are
Lordship, further to that, Your Lordship may kindly see Annexure 3 to the writ appeal. That observation has been further clarified by the Honorable Judge.
Because of his order, he has altered his position.
Page 53 of the writ appeal. Is the order is at page 55, Your Lordship finds. The prayer that the appellant has made here, the same prayer was made before the Honorable Judge in the IA, and the observation Your Lordship may kindly see, para 5, learned counsel for the petitioner on the contrary has filed an objection to the application for modification of the judgment. He further contended that pursuant to such observation, he has preferred an appeal before the appellate authority. The same is pending disposal. He further contended that in view of the aforesaid observation, he has already altered the position and withdrawn the other writ petition which is pending before this court. It is also contended by the learned counsel for the petitioner that if aforesaid observation is taken away at this juncture, then the same will virtually make the petitioner remediless. Considering the submissions made, the observation that Your Lordship just made that he has to raise all the issues, that observation has already been passed by the Honorable Judge.
That is after that another IA was filed.
Yes. That on 11/4, he justified the omission, disallowed my prayer for expansion, that he defended his own observation. With taking advantage of that,
I understand. Okay.
Illegal observation.
And pursuant to this, Lordship,
in August, well, I waited from 17 to.
All it come at 2 will continue.
We have to act two programs some difficulty in
Sorry, I will not grant any adjournment because I will pass only dictate order at 2. You are there if
I'm here. I'm very sorry, I'm apologetic to have hot your lock.
Suppose of Korak and the Jagannath temple and just giving. And not many people.
What is this?
Status report on Jagannath temple, man.
Matter has been called out.
No, that is item 28. Is mentioned. 24.
You can file it because we do not know. When we call out, better you give at that point of time. It is called out. You are coming back. No.
They want to take adjournment. That's why.
No. Nobody has taken adjournment into it.
No.
Nobody has taken adjournment. Don't worry.
He is submitting that I am submitting my report today, so it may come on another day. That is his submission. He is amicus curiae.
He wants an adjournment.
Yes.
No.
He says he wants to leave to place this report before us. Have you supplied copy to Mr. Mohanty? All right, you be there.
No, I have not received. I have not received. I have received today.
My learned friend is amicus curiae, who given a report, and my learned friend appealing for ASI also additional affidavit. It has not been lawsuits, and he sought a copy on me, Lord. So I will take instruction on that affidavit.
Let us pass the order. It requires passing of the order by in the mention. Is very difficult, and this is not also the mention of. You all of a sudden come with a matter in the proceeding that creates a lot of disruption. Please don't do this. Keep it open, huh? Yes.
If your lordship allows me, only one fact I'll assist your lordship. I had put a question that after rejection of the review by the controlling authority, was it challenged? That was challenged and that was the subject matter of WPC 20266 of 2017, which ultimately I withdrew after the review gave me this liberty and I prefer the appeal.
No, that part we will explain, I will tell you very frankly. They may also raise in one issue that your review was rejected by the controlling authority. Right. We are not expressing anything more. That can be a ground also challenge the appeal, maintainability appeal. But there is another issue that will support your case, that there is no review power. So that bar of this order 47 rule 7 will not come perhaps as a principle also. So, but you have anything to say more? I think you got our point.
Miller, I would only just put the two sentences.
Yes.
Once the Honorable Solicitor granted the so-called liberty, he filed an appeal. Also misplaced appeal, because he knew the DLC is the acting JLC of an authority. So he should have preferred the file appeal before the complaint appeal authority. That he did after the period.
All right. This will only observe in respect of this situation
where there is no authority.
That this observation cannot be treated as a leave. Subsisting right to appeal, his appeal will be maintainable. That we will observe. Irrespective of that means that we are also interfering with this way. But we have interpretation. This will not erase, create a lot of problem. I think we will interpret this part. What is this application, or what will be the consequence of this part? That much we will interpret. Nothing more than that. It will create a lot of things because already you have participated there.
No, in the second appeal,
no. The second appeal, he says you have appeared there, you filed an objection.
Only I appeared on 5th and filed some petitions. They are yet to be answered.
All right. You continue that objection. That is there.
I will do, because the review court has given that unreserved observation that therefore
just forget that I. This IA order is at what page? This after the review petition was this
page.
IA.
Yes. Page 53, your lordship, Annexure 3.
The lordship granted 2 months to close that appeal. There has been now 5 months.
All right. That I cannot. You understand that I am not sitting over any order of this appeal. You filed an application there because it is a payment of gratuity. You understand, they will decide it. The purpose of this controlling authority on for expediting the payment of the gratuity. And this just go and impact on this appellate authority.
I am happy on the point of limitation.
Don't bring all these things are not before us.
Miller.
All right. By means of this writ appeal, the observation made in the judgment dated 17/2/2023 in RBWP 80 number 233 of 2017 by granting observation made as regards the further legal action has been challenged. Stop. Mr. S.K. Mohanty, London Council, appearing for the appellant, has submitted that except the following observations, the appellant doesn't have any other grievance over the impugned order is concerned. Stop. Colon. Page 42. However, if the review petitioner is, so advised, he may assail the order passed by the controlling authority in an independent proceeding lodged at their instances on court. It has been stated by Mr. Mohanty that taking advantage of this observation, the employer has filed a statutory appeal against the order against which a review was filed before the controlling authority and the same was dismissed. Stop. The legality of the said order rejecting the review petition was challenged in the writ petition, being WPC number
20266 of 17.
18066 of 2017, which was dismissed by the order dated 4/9/2017.
That is 20266 of 17. His petition. 23 dismissal.
What are you saying?
20266 of 17. He withdrew his petition. It was according to dismissal 28/3/2023.
Just come to you that this review application, the review
of my application 18066 of 17. He sought review of that order 4970.
No, who filed this WPC number 18066 of 2017?
I filed.
All right.
Direction to expedite recovery procedure.
All right. No, so this.
Yeah.
Sorry. This last one. Oh no, the said order rejecting the review petition has not been challenged by the employers. Stop. But the opposite party, but the appellant hearing, the opposite party in WPC number 18066 of 2017.
I was petitioner. I was
So that order was challenged in 20266.
There is a two petitions.
Two writ petitions, Your Honor.
And he filed
18066 was on his behalf for recovery. And
18066 is whose risk petition?
That petition was by the employee for recovery of the amount due. And 20266 is by the applicant, by the employer.
20266.
20266.
He filed writ petition
against the rejection of the review by the that I withdrew after disposal of the review and filing of the appeal, statutory appeal.
All right.
Review was also by him later.
Again, we said order of rejection of the review petition. The employer filed was a separate writ petition, being 20266 of 2017, which was ultimately withdrawn after the judgment dated 17/2/2023 was passed by providing the above observation. So, the employee, the appellant hearing, had also filed a separate writ petition being WPC number 18066 of 2017, seeking expeditious implementation of the order of the controlling authority. And that petition was allowed. Stop. Against the said order dated 4/9/2017, the employers respondents number 1 and 2 filed a review petition being RBWPT number 233 of 2017. The said review petition has been dismissed with the above observation by the order dated 17/2/2023. Stop. Only on the limited ground that noted above, this appeal has been filed. According to Mr. Mohanty, learned counsel appealing to the appellant, the said observation is wholly unwarranted in the circumstances of the case. Stop. He has asked this court to expunge this observation, taking away all its consequence, whatever that has happened in the meanwhile. Stop. Appearing for the employee, respondents number 1 and 2, Mr. A. Mishra, learned counsel, has brought our notice to the order dated 11/4/2023, passed by the learned single judge in IA number 103 of 2023, arising from the RBWPET number 233 of 2017. Stop. The said interlocutory application was filed by the appellant seeking modification of the judgment dated 17/2/2023. But the learned single judge, having referred to the observation as reproduced above, held that court. This court is not inclined to interfere with the judgment dated 17/2/2023. However, it is made clear that it is open to the opposite parties to raise all the grounds, including the grounds. You filed this petition?
No, Lordship, this was filed by him for modification.
What is the observation? The opposite parties to raise all the grounds?
Lordship, he was the opposite party in the review petition. I was the petitioner in the review.
No, not specified. Was specified open number 4. Some confusion.
All right. However, it is made clear that it is open to the opposite parties within the appellant's hearing to raise all the grounds, including the ground of limitation before the appellate authority. And in the event of such grounds are raised, this court is confident that such ground will be considered by the appellate authority while deciding the appeal referred by the petitioner, within bracket the respondents number 1 and 2. Further, it is made clear that considering the fact that the matter is lingering since long, the appellate authority is further directed to make every endeavor to conclude the appeal as expeditiously as possible, preferably within a period of 2 months from the date of production of the certified copy of this order. Unquote. Stop. The said order has been also challenged, has also been challenged in this appeal. Stop. Mr. A. Mistral and counsel has submitted that based on the said observation made, the appeal was filed by the employers and it is pending before the appellate authority. And in the proceeding, the appellant has already participated by filing an objection regarding maintainability of the said appeal. Stop. Be that it is made the sole question that falls for consideration that if the aggrieved person is entitled to the remedy of appeal, can that be taken away finally by court while deciding a right whether the relief granted by the controlling authority, no, when the grievance as projected is that the relief granted by the controlling authority is not being implemented. Stop. Even if the review petition is dismissed, the appellate authority can consider that whether the appeal is maintainable. But the court cannot take away the right to file appeal when there is no dispute that the controlling authority doesn't have any reviewing power. Having observed this, we observe, having observed this, we do not find any merit in this appeal, and we direct that observation passed in IA number 103 of 2023, since has not been challenged, be observed by be taken care of by the appellate authority in terms of the stuff. There should be no arrest to cost.
The statutory limitation period.
We raise all the questions we have to, we are not touching it. Only thing you asked is that 2 months time. And a single judge has already granted 2 months time. We only observe that should be followed by the appellate authority. And your objection, everything is within you. Whatever objection you can write to take there only, not here.
Lordship, can I take return of my brief?
Sure. That is what I am searching for.
That observation still remains.
Observation remains. It doesn't affect you. And then a single judge has clarified that observation.
That is the backbone of their offense.
If we say that they have an appellate right, I say they cannot take the observation, that it will come in conflict with the observation.
Another round of explanation will continue.
Let me, if the law permits,
6 years.
You go there and urge differently. It is not the forum for you to urge this implementation of the award and other thing. All right.
Totally. Item number 20. In this case,
The opposite party number 12,
20. Yes.
has encroached the forest land and started non-forest activities inside the forest land. And in the counter file on 12/12/14, the opposite parties have admitted that encroachment in the forest land has been done. The illegality have already been done. Now, after 9 years, opposite party number 12 has appealed in this case and filed a counter.
And what is appearing for the opposite party number 12?
For opposite party number 12, Mr. Ramesh Singh is appearing through DC.
All right.
So I'm appearing for respondent number 12. Now, she may just make one submission for Lordship on this.
No, yes, submission.
In the last occasion also, my lord, this honorable court has directed the present status of the case, and in the counter file, an additional affidavit file,
yes,
on 23/3/2023, this year, 23rd March, a field verification was conducted jointly by the Revenue and Forest Office.
Yes.
That's a para 3 and 4 of additional affidavit filed on 8/5/2023 by opposite party number 2, 5, 6, 10 and 11.
So H2 is the report. H2 of that affidavit is the report, page 122.
And come to the counter affidavit filed on 12/14. There was a joint verification as conducted.
That is talking about this annexure H2. Is it the report? A report of the joint inquiry on
joint inquiry.
What is the finding? Who is the abbreviated form of IBEUL? What is this?
This is opposite party number 12 in Bharat thermal power.
Energy.
Bharat Energy Limited. And the DFO has stated that this CBL is not doing any construction over the land. This report, this come back again.
It's the present status of the case.
Just count the last line of the report. IBEUL is not doing any construction work over the plot number 6.
But already they have acquired a land, 14.52 acres of land.
Have you filed it? After that, have you responded to that?
No, they have admitted it.
Where they have admitted it? 12 has not filed any counter affidavit.
Oh, yes, 12
have filed the counter
affidavit. And on 24th July 2023.
Oh, yes, all right. I got it.
Right.
In which paragraph they have admitted it?
My lord, in the counter affidavit from the very beginning, my lord, on 12/12/2014,
come to the paragraph and the line that shows
the joint verification was conducted first in 12/12/2014 by the range officer and staff of Revenue Department. As per the joint verification report, OP number 12 has committed violation. It is an unauthorized possession of 14.52 acres of forest land without obtaining prior approval under forest conservation. Where are you reading it? Under counter affidavit dated 12/12/2014, page 5 of counter affidavit.
Filed by the other opposite party, the Divisional Forest Officer. Page?
The latest affidavit of the government is 24th July.
What is your stand there?
Government affidavit.
Who is opposite party number 10? Last time there is an affidavit filed by you.
Main is DFO Jharsuguda. Government.
What is that? Regarding construction, you have not stated anything. You are talking about the de-reservation of the forest. Yes, Mr. Singh, that you have admitted this, that you have constructed on a 14.12 acre of land.
Lordship, may I just, I'm sorry, Lordship, that's an admitted position. There was definitely an encroachment on the forest, and we have to start from that. Lordship, we are not running. Lordship, may I just, it is just number 12. What had happened, Lordship, this matter was taken up in 2014. And the last hearing took place in 2014, and then it was taken thereafter, after 9 years, only in March of 2023.
Yes.
A few things transpired in between, Lordship, and that's my duty to point out to my Lord. And Lordship, may take it that we are not running away from the fact that rather respond to that there was encroachment. Now, what had happened, my Lord, after the last hearing in February of 2018, the Regional Empowered Committee of the MOEFCC, my Lord, they had taken a decision. They said, well, yes, there is a forest diversion, one. Number two, that there'll be penalty which will be imposed, and ultimate decision will be taken on that. But then they say, well, we are not going to go finally because the matter is pending before the High Court. They invoke a guideline Roman 2.16, my Lord. They say, well, the matter is pending, we will keep our hands off. That's what happened in February 2018. Thereafter, my Lord, what happened in August 2018, this company, my Lord, which is respondent number 12 before, my Lord, went into CIR.
Yes.
14, that's an undisputed, again, an undisputed position. Now, Lordship, we are JSW Energy, my Lord. We have taken over the management. We became a resolution applicant before the NCLT, my Lord. And we have, pursuant to a resolution plan, we have taken over the management of respondent. And in our resolution plan, we have clearly accepted, Lordship, necessarily I show that to my Lord. We have, in the part of a resolution plan, that we will take remedial action and we'll put in a proper forest diversion proposal. Lordship, mistake has been done, but some mistake can it be rectified through some penalty, afforestation? That's the whole point, and that was a part of a forest diversion proposal. That forest diversion proposal, Lordship, when we came into the seat, management seat, we placed it before the MOEFC. We also shared with the state government. Lordship, they were not looking at it at all, Lordship, because of this pendency, because they invoke guideline 2.16, matter is pending before the High Court, we will not look into it.
But there is the order dated, just a minute, the order dated 17 May 2023.
I'm so grateful, Lord. That's exactly what I was coming to. And therefore, at that stage, we made that submission. I'm so grateful, my Lord. And therefore, we were constrained to make the submission, which were kindly recorded by the early Chief Justice on 17th May 2023. Yes. I'm so grateful, Lord. And that's and once we did make the submission, they have taken up, and things have moved from there. After the 17th May 2023, Lordship, 3 decisions have happened. Lordship, on 13th June 2020, Lordship, may just have my latest counter, Lordship, and I can just show that to my Lord from there. after what has happened after 17th May 2023, if my lord may have OP12 counter affidavit, which is in place before my lord. Now, pursuant to that, after 17th May, my lord, kindly have that.
Is your additional affidavit?
That's correct. That's my additional affidavit. And that my lord,
Yes.
my lord is open. If my lord may be kind enough to come to page annexure L2, page 9, my lord. That's the next event after my lordship's order of 17th May 2010. Page 9, my lord, of my additional affidavit.
Yes.
And lordship, that minutes of meeting, lordship, are case is taken up from page 31 onwards. So that's a comprehensive for other meetings. Our plan, this particular lordship project is taken up from page 31 in that 13 June 23 meeting. Agenda 89.5. Page 31 top, my lord. Diversion of 34.63 hectares out of so-and-so revenue forest for establishment of so-and-so.
No, we are concerned with a very short point, Mr. Singh. We are concerned with the allegation is that you have unauthorizedly occupied the forest land.
No, we have, lordship, that has happened. Lordship, that has happened. What can move forward? And that's exactly
how that can happen? That is the question in the public interest.
No, lordship, that's an erstwhile management. Lordship is absolutely correct. Can it be can it be condoned in law? Lordship is an issue which we are presenting. Lordship,
we are not the authorities. Can we condone the authorities that they are?
No, lordship, not. It's the MOF who have done it. Lordship, that's exactly what I'm showing the decision. Lordship, that's exactly, and that's the decision I'm showing to my lord. My lordship has straight away come to that page 31 at 38. The decision has been taken, my lord, and that's what I wanted to place before. I'm so grateful. I'm not page 38. Lordship, I paragraph 41 first, and then I come straight to the decision, which is immediately thereafter. Paragraph 41, that's our submission. However, the user agency, be it so-and-so, addressed to so-and-so, so-and-so has informed that Tehsildar has disposed of 8 number of encroachment cases with levy of assessment and fine, and IPPL deposited assessment fine with Revenue Department. It will also inform that the state government has filed additional counter affidavit on so-and-so in light of the joint field inquiry report dated 21st December 2015. The company is willing to pay the penalty as would be decided by the government and would be abide by the decision of the Honorable Court in the judicial case. Lordship, before that, if my lordship may just allow me to place paragraph 32, that's the learned advocate general opinion at page 36. Then I'll come straight to the decision, which my lordship will get at page 36 of the same decision, paragraph 32, my lord.
Yes.
And that's what also considered, my lord. In view of the legal complication and pending PIL case involved in this case, the matter is also referred to learned advocate general. So for his view, after detailed examination, learned advocate general has defined the matter which is reproduced below. Keeping in view the aforesaid background of the matter, I find Principal Secretary Government Forest so-and-so has given 2 options to refuse the recommendation for diversion of forest land. However, this option would scuttle this project as 700 megawatt coal-based thermal power plant, which is an MU project as well as commissioning.
I have read that part. So, what action you have taken against your divisional forest officer when this land of 14 point such odd acre was occupied by this company? Presently, the other company has come into by taking over the management.
My lord, as per the direction of the Honorable Court last order,
yes,
the affidavit has been filed by the state government. Lordship may kindly have a glance.
I have seen it.
24th July.
But my question is, this opposite party
diversion proposal is pending. It is
no, Mr. That is not the issue.
Yes, my lord. During that period, there was an encroachment of forest land.
And your this divisional forest officer has given a statement. There is no construction.
Yes, my lord.
So what he is doing? Some huge part of the forest land is enclosed. A construction is going on. Who will protect the forest land? Court or the divisional forest officer?
Divisional forest officer is to protect.
So what action you have taken? Or it is a collaboration between the state that you occupy, construct, and then we will ask for the regularization because huge investment has been made? It is a case of hand in glove, I am telling you. State government cannot function like that because the management and protection of the forest is you. You cannot change the forest plan. For that, you need also the central government environmental department's clearance. For even then, after this act has come, Forest Conservation Act.
19.
Yes. Now it is a joint task of both the central government and the state government to de-reserve any part of the forest land for any other purpose.
And that proposal is pending.
We are not concerned. We are concerned on the first part. What your officers were doing during this encroachment.
There was an affidavit in 2014, my lord.
No, you can file the separate affidavit, but these things are under the public trust doctrine. If this is the trust you are just carrying on, citizen cannot have any hope with this kind of administration. You are coming with now, there have been construction, we are going to regularize it. The entire forest land will be one day regularized this way.
Lordship may have a glance at the affidavit which the
opposite party number 2 has filed.
Under Secretary to Government, that is 12th December 2014.
2014 affidavit. Okay. Come to that.
That is also
2014. Page 5 of counter affidavit, page 14. It has been clearly mentioned in page 5 of 4 and 5 of.
We have issued so-called notice.
In which affidavit? Main affidavit that you have filed. By 2, 5, 6, 10 and 11.
This is perhaps the first affidavit which was filed in 2014.
2014.
14, page 5, my lord, a joint verification has been conducted.
Now that we have noticed. Second, 3rd March 2016 affidavit, Mr. Mahanti.
No, this affidavit, why I am showing this affidavit to your lordship, page 5, kindly see, last paragraph. Further, the departmental proceedings have been initiated against the concerned forester and forest guard for the same by DFO office order number so and so, respectively, for not reporting the unauthorized encroachment and failing to prevent.
I am not getting it. Which affidavit you are referring?
Oh, sorry. My lord, this is the affidavit of one Guru Chana Samad, working as Under Secretary to Government Forest Department, dated 12th December 2014.
Please, 53.
57
12 2014.
57.
Open it.
Page 57.
Next counter. Okay. Oh, this is by 2, 5, 6, 10 and 11. This is a combined counter affidavit. In which para you are reading?
Yes, my lord. 2, 5, 6, 10, 11. All. Paragraph. Page 5 of that internal page.
Yes.
Further, departmental proceedings have been initiated against the concerned forester and forest guard for the same.
Page?
Internal page 5 of that particular counter activity.
All right.
For not reporting the unauthorized encroachment and failing to prevent such encroachment of forest land by the opposite party, note 12. The illegal construction works on forest land are not going on since are not going on since it as reported by the range officer and Jharsuguda division by his letter number so and so addressed to DFO Jharsuguda, and the range officer has also been instructed by DFO's office so and so to seize the materials used for the forest land, copy of the letter number so and so is sought. Hence, the question of connivance with the same government, some government officials is not a fact and denied here. The next para is also important, that with regard to the arguments made in so and so, it is humbly submitted.
Just this is a 22/3. 2014, the letter date, right? By the letter it says that that was done and that was done, and after that, you just come to another counter affidavit now.
No, only thing my lord wanted to know what action has been taken against the person.
No, this is not no action. You come to the running page 284. This is a part of the affidavit filed by the opposite party number 10. And page 4 of that counter affidavit. This is a affidavit filed by the opposite party number 10.
10 only 10.
And annexure A10 to that affidavit.
Lord, it is that.
Have you got this order of the?
I 10. Get some date
24/7.
24/7.
No, this is annexure. Or this the affidavit filed on
24/7.
24th July.
July.
You come to there is annexure A10.
Order.
Yes, ma'am.
Just come to this page number, internal page number 4 of that affidavit.
In the meanwhile, complaints were received regarding illegal construction activities in forest land prior to approval under Forest Conservation Act 90. Though memo, this is.
There was a complaint, the page 4.
Yes, ma'am.
Running page 285.
Last para deals with field inquiry conducted in compliance of the those.
This page 4. You come to the last paragraph.
A joint inquiry
yes, just
given on 21 by a committee consisting of Assistant Conservator, Deputy Collector, so and so, reported that 8 encroachment cases were instituted against this company for unauthorized occupation of government land.
Yes.
Yes. That is also mentioned in the first affidavit, which I pointed out before your lords. Encroachment cases were initiated. Disciplinary proceedings were elicited against the persons who did not report the fact of encroachment to the authority. And in the meanwhile, diversion proposal has been submitted and it is sent to the MOEF.
The violators can also get the leniency from the government.
That is, my lord, by order of the...
I am asking you a final question that you decide now. One order has been passed in the interim nature. They are asking you whether you go for that. We are not here to show our misplaced sympathy for the violators.
No, it should not be. Not
This your own report says there is 8 cases of violation. Yes. Do you think, Mr. Mohanty, that we all understand certain things with a little bit of intelligence? 8 cases by the same company, and that is not noticed by your officers.
Must have been noticed because it is open.
Lordship, may I just come in here? Lordship, this 8 violation has been addressed, my lord.
No, but you have admitted that you have violated, not
I just said, Lordship, hostile management. I'm not different. I'm saying something else, my lordship. Lordship, that order I was showing of MOEF, my lord, that 13 June 2023. If my lordship may just come back to para 41 again in my affidavit, my lord. Even this order which my lordship is placing is also part of my affidavit. That's at page 43. But if my lordship may come, I was showing my lordship may just come back. If my lordship may just give me that intelligence. My 13 June 2023, that in my affidavit I put that MOEF decision of 13 June 2023. It's my lord, that additional affidavit begins at page 9. And if my lord may come to page 38, para 41.
Your affidavit?
My additional affidavit, my lord. Additional affidavit. If your lordship, I was placing that.
Yes. Para?
41, my lord. Just come to para 41, page 38. That's part of the 13 June 2023 decision of Regional Empowered Committee of the MOEF, my lord. Page 38, para 41.
Page 31.
38, para 41, my lord. The decision begins at 9. I'm only pointing on the relevant portion of that MOEF decision. 9 at 38, para 41.
Yes.
However, the user agency with a letter of 4th September 17 addressed to Special Secretary.
No, just a minute. Let me get it. These are minutes of 89th meeting of the Regional Empowered Committee.
That's correct, my lord. Which my lord is begins at page 9. My lord has got the 89th meeting.
Yes.
Page 9. Yes. And the relevant portion which I was reading, my lord, at page 38. The running page 38. Okay.
Yes.
May I place it, my lord? At para 41 is what I'm placing. However, the user agency with a letter dated 4th September 2017 addressed to Special Secretary Forest and Environment, Government Odisha, has informed that the Tehsildar Lakhanpur has disposed of 8 number of cases on 25th April 2017 with levy of assessment and fine, and IBPIL has deposited assessment and fine with the Revenue Department. So Lordship, that's insofar that 8 cases my Lord was had.
I am not getting exactly this paragraph you are referring to.
I'm so sorry. My Lord has got page 38. 9 at 38.
38.
38.
330.
38.
Yes.
Para 41, my Lord. 41, para 41, my Lord.
38 is the 41. There is no 41 in that page. I'm a little confused.
I'm so sorry. Let me read. Lordship, page 9 is that 89 decision, MOF regional empowered decision. 89, that's at page 9. It starts at page 9 of my additional affidavit.
Yes.
Page 9.
No, Lordship, page 9 is at the top. If you Lordship just scroll down and come to page 38, 38.
3A, okay.
38. I'm so sorry. Minus. 38.
3A.
Para 3A of the counter affidavit. Additional affidavit.
38.
38. 38. That is 38.
38.
My Lord has got 38.
38, para 41.
Do it.
Para 41, my Lord. Lord, you can see para 41 there at page 38.
Yes.
May I place it? However, the user agency, with a letter dated 4th September 2017, addressed to Special Secretary Forest and Environment, Government of Orissa, has informed that the Tehsildar Lakhanpur has disposed of 8 number of encroachment cases on 25th April 2017 with levy of assessment and fine, and IDPIL has deposited the assessment and fine with the Revenue Department. So, Lordship, this was taken care of way back in 2017 itself, Lordship, so that encroachment purpose.
So you are not in possession of those lands?
No, Lordship, that's all gone. That's all history, Lordship. I'm so, yes, we have already, that's been done way back in 2017. Lordship.
You are not
Lordship,
in possession?
No, Lordship, the only issue now remains is the forest land which were used for non-forest activity. So
I am asking a very simple question. Are you in possession or are you are not in possession?
No, Lordship, there are two things. Insofar as forest land is concerned, that is part of my project. The mistake which was done by the erstwhile management, that they should have taken a permission prior to using it for non-forest.
No, that we have understood. But my question is very straight to you. Are you in possession of those land as yet, or you are continuing in the possession or not?
Not, Lordship, not of this. Mr. Mahapatra,
we are in possession of those certain portions of those lands, my lords, and we are cooperating with the government. Well, I'm appearing through VC here, assisting Mr. Ramesh.
Mr. Mahapatra, that question is very clear that 8 cases of this forest encroachment have been disposed of with levy of fine. Yes. By levy of fine, whether your possession has been regularized or if not, how are you still encroaching the part of the forest land?
Well, it's the parts which were encroached upon are on the same land for which we have sought of forest clearances for non-forest activities. Now, the encroachment cases were initiated by the state.
Mr. Singh has read out to the para 41 of the minutes of the committee, and it clearly says there was 8 cases of encroachment cases on 25th of April 2014. Those were disposed of, and with levy of fine, and IDPIL has deposited the assessment and the fine with revenue, informed the state government has filed additional counter affidavit such and such. What does it mean? Try to understand the levy of fine, and the government is allowing to continue in the possession. Is it the situation?
Yes, my lords. My lords may see just below that decision of the REC, the second paragraph. It makes it clear. The committee decided to recommend for regularization of the area of forest land over which construction activities have already been done in violation of the Forest Conservation Act and balance forest property.
Mr. Mahapatra, there's a difference. If you have been leased out that land and it is forest land, you are applying for regularization, I can understand. But if government land you have encroached without authorization, how can you apply for regularization of forest land? Because that has not been leased out to you.
Lordship, I think, Lordship, in all fairness, Lordship, I'm so grateful for that query which is from my edition. Insofar as 8 lands are concerned, I think we should go back, take instruction, and come back on that, Lordship, to be very, very fair to the court. I personally feel, Lordship, as an officer of the court. Lordship, the land which I already have.
Mr. Mohanty, just you clarify now. What does it mean about the 8 encroachment cases you have disposed of by levying of the fine? What does it mean? What is its implication and consequences? You are levying fine without just evicting from them on the land.
That is the
strategy.
No, that is what has been.
The levying fine means it is encroachment.
That means
how can they be permitted to continue with the encroachment? They have admitted the encroachment and paid the fine for that those years.
That penalty should be followed by an eviction.
Should be. But
Lordship, has it happened as a matter of fact, Lordship? That's the query which is falling from the bench.
No, we understand, but
Thereafter, if the land
problem is that perhaps we are encouraging the persons who doesn't have any respect for the law to occupy the forest land in this way, and thereafter going to the government, and government will say, see, they have invested, so we are regularizing. This is the trend everywhere. I think you are aware of the JP case in Himachal Pradesh.
Yes, Lordship.
What was the decision of the Himachal Pradesh High Court, and what happened after the Supreme Court passed the order? They constructed a hotel without taking permission, and they have been evicted from that with a fine of only rupees 100 crore.
Lordship is absolutely correct. Lordship, I was just on one point. Lordship, there are two aspects. Ladyship is correctly pointed. One is by diversion for a non-forest activity, which is my land, leased land. One. Number two, the encroached land.
That we have no problem in understanding, Mr. Singh. We have certain duty when it is a matter relating to the public trust doctrine. You understand? Nobody is looking after those things.
Lordship, as I said, Lordship, as an officer of the court, we should come back to my lord and indicate what has happened to that 8 encroached land. Is it still with us or is it gone with the fine? If we have paid fine and as the assessment done and this gone back to the...
That is, I am asking from Mr. Mohanty that what does it mean? Allowing them to continue.
No, Lordship, I don't think that would have happened, Lordship, but we can come back on that. In all fairness, Lordship, that's a very, very valid question. Is beyond the forest diversion.
You vacate the premise. We are giving you a time for 15 days and continue the hearing. Whatever the outcome of that proceeding is the central government. You vacate it first.
Fair enough. I think
You took up the matter for 15 days. Yes. Vacate entire
Lordship may keep it after 15 days, Lordship, and
granting you 15 days.
that encroached part, I think, should be addressed and taken.
All right.
I think Lordship can, yes, Lordship can just keep the matter back with 2 weeks. I think that should be addressed first, Lordship.
Oh, yeah, you're giving the 14 days time, this 2 weeks time, we are granting you for vacating the forest land. But Mr. J. Patnaik and counsel appearing to the petitioner. Also heard Mr. D.K. Mahampil and additional government advocate appearing for the state opposite parties. Mr. Ramesh Singh and senior advocate assisted by Mr. D. Mahapatra and Ms. Asharja Rai and counsel for the opposite party number 12. Mr. Pari is not here, I think.
No, I am. One.
You're there. Mr. Rai Guru and counsel and central government counsel appears for the Union of India respondents.
1 and 3.
Respondent number 1 and 3. Stop. In this public interest litigation, allegation has been made by the petitioner that the opposite party number 10 has enclosed the forest land Stop. The encroachment has been admitted by the opposite party number 12. In their counter affidavit filed on Between 5/2023. In the said affidavit in para 12, point C, it has been stated by opposite party number 12 that the total land requirement of the power plant project is 23.90 HA hectare, which includes 35.985 hectare HA of revenue forest land. The said revenue forest land comprising in area of 21.898 HA in the village SUBHASIS and area of 14.087 HA in village Barpali under the Lakhanpur Tahsil of Jharsuguda district. Stop. It has been also admitted that having encroached and constructing a building on a part of this occupied land, the opposite party number 12 had applied for diversion of the forest land at measuring 35.985 HA for establishment of the power plant. Stop. It has been also admitted by opposite party number 12 company that they had been carrying on construction of the power plant unit and setting up transmission tower for linking the power plant with the eastern power grid. Stop. On 4/9/2013, they received notices. On 4/9/2013 and 19/11/2013, the opposite party number 12 has received notices from the district forest officer Jharsuguda to stop his construction activities for being purportedly carried on forest land. Thereafter, on 12/1/2014, an inspection of the LS construction were undertaken by the range officer, Brajraj Nagar and Revenue Department staffs of Lakhanpur Tahsil. In the report submitted pursuant to the joint inquiry, it was alleged that opposite party number 12 had constructed boiler, turbine, track hopper, chimney, etc. over the forest lands and at measuring 14.52 in Moja, Sahasbahal and Barpali. Stop. It has been also admitted by the opposite party number 12 that 8 encroachment cases were instituted against them and they were levied fine. Stop. At the juncture, we asked Mr. D.K. Mohanty, learned counsel, appearing for the opposite parties number 5, 6, 10, and 11, that after levying fine, whether the opposite party number 12 is still on the encroached land or not. Mr. Mohanty, of course, could not give any answer. It is obvious the opposite party number 12 did not remove the structure and the machineries that they set up on the said forest land. Stop. By the order dated 17/5/2023, this court had directed that the proposal submitted by the opposite party number 12 for diversion of the forest land be considered in accordance with law, and after hearing learned counsel for the opposite party number 12, a reasonable order should be passed in that regard not later than 1st July 2023. Stop. It was also directed that the state government shall file an affidavit, and accordingly, the affidavit has been filed by the opposite party number 2. This is the affidavit you filed?
That is the Under Secretary to Government. The government has filed
Under Secretary to the Government, Mr. Parinda. Because this is the last affidavit.
Yes, that is the last affidavit.
First, this is the compliance affidavit.
This is the compliance of the interim order.
Filed on 1st August 2023.
1st August.
Stating that the proposal submitted by Messrs. in Bharat Energy within Utkal Limited for diversion of forest land be considered in accordance with law, and after hearing from the learned counsel for opposite party number 12, a reasoned order should be passed in that regard not later than 1st July 2023. Stop. It has been stated that the appropriate authority for according approval for diversion of 34.63 HA out of 35.985 HA applied for is the revenue forest land of the revenue forest land for establishment of 2 to 350 MW coal-based thermal power plant at Shahabbahan and Barpali villages under Lokhanpur Tahsil in Jharsuguda district. Is the Ministry of Environment, Forest and Climate Changes, Integrated Regional Office, Bhubaneswar, opposite party number 3. Stop. It is obvious that no such approval for diversion was granted so far. But surprisingly, the opposite party number 12 is still on encroachment, as the fact relating to their encroachment has not been stated in any affidavit. Stop. Without drawing any conclusion or inference in this stage, you direct the opposite party number 12 to vacate the forest land and removing all the structures and machinery from the forest land within 15 days from today.
Lordship, may I just answer?
Yes.
Lordship, there are two things, as I said. There are machinery, the construction on forest land. Now, the forest land, as Lordship correctly pointed out, this 8 number of encroach. Now, is there a forest lease land which I have got? Those are not encroachment. Lordship, there could be some land which is encroached land in forest area.
No, we are right. The forest land for this purpose will mean the land which are under the 8 encroachment cases.
Yes, Lordship. And if not already vacated, Lordship, because we...
of course, if it is not already vacated,
yes.
The opposite party number 2 is directed to file an affidavit indicating whether the opposite party number 12 has vacated that forest land or not. Let the matter be listed on 4th of September for passing the further orders.
This order may be uploaded today so that immediately I will.
Try, yes, we'll try. A copy of this order will be supplied to Mr. D.K. Mohanty free of cost forthwith.
She was in kind enough to keep this matter at 2 o'clock. Can I request for the same? Reiterate that request. Okay.
2 p.m.
I'm so grateful. I'm so grateful.
And Mr. Mohanty, if I find that without their vacation, you are proceeding with this approval matter, I will ask your officer to come here.
No, we are not the approving authority. MOEF is the approving.
I understand. You are processing the matter as per the order. Our order, this is
with all the findings, all the observations, we have just placed it before the MOEF.
I think that should be the principle of the state government. Unless someone is encroaching the forest land, they vacate it and make the due compensation because they have caused the damages to the forest. You should not consider their any proposal, whatever the very important for the development of the power generation. All right.
Grateful, man. Extremely grateful.
67. Item number 67.
Another item was fixed pilot at 3 p.m. My matter was 67. So there's 2 p.m.
Can we, Mr. Rai's matter will be after tomorrow? Tomorrow is holiday.
No. Before the freedoms and the Independence Day. Let them get some freedom also. Why are you unnecessarily harassing these people?
Yes.
There is no serious allegation against them. We hear Mr. Rai today keep it quarter to follow on the 16th. At least some progress he can make.
Correct, man.
Mr. Rai,
49.
I'm 150 mentally handicapped children are there, and every month I'm contributing balance 50,000 every month.
Mr. Rai, you are contributing personally? Or?
Yes, personally balance 50,000. I can also. I have got the screenshot.
No, that is a commendable thing.
Yes.
Even if they win the case, you should continue. No, because it is for the interest of the children.
Yes. And Pari, this just see this. This is not an issue the central government should fight with a small organization. I have seen your report. That is why I am telling all these things.
My lord, we have prepared the report and the report was clarifying about the diversion of the fund. Only one thing, but this report cannot diversion what they are utilizing, it cannot be reflected. I call that officers and to him. They have not only diverted the funds fund for the government of India, what is coming, diverting the FCRA.
Government of India's fund, they are not receiving number one. They are getting the foreign contribution, that is the FCRA.
Yes.
And they have stated for the purpose that we are receiving the fund only spending the fund for that. Yes. And your officer says they are doubtful, they are involved in the conversion.
It's a fact. That purpose the funds is coming, they are not utilizing that purpose. It is admitted it was diverted.
Who admits that it is diverted?
On inquiry, it was found that it was diverted.
Inquiry was found
that it was diverted.
Inquiry, this report is with us, not with you.
That's why I am submitting the report.
That is why the report is not with you.
Now, question is the FCRA matters are pending with the Supreme Court.
So that is
they will decide. The Supreme Court decision will be
regarding the amendment. I am not challenging the amendment. I am challenging
the funds is coming. The FCRA is not binding.
On that submission, we have taken enough time that the matter is pending before the Supreme Court. And that is the matter relating to the amendment challenge was made. I am not challenging any amendment. I am challenging my.
This 47?
49.
49. Take down the 49.
Item 49.
Mr. Esfeld and his senior counsel appearing the petitioner in part for continuation of hearing is the matter on 16 and 20.
16.
Mr. P.K. Pari is, and Mr. B.S. Raiguru and Mr. P.K. Pari, Deputy Senior Solicitor General of India, and Mr. B.S. Raiguru, CGC, has appeared for the Union of India respondents.
Can it be at 2 p.m. my lords? Or on that day again, my lords, I have to mention. I will also say. My lords,
2 p.m.
2 p.m.
And Mr. Pari, please come at 2 p.m.
Yes.
My lord is 16th or 17th?
16th.
16th 2 p.m. Mr. Paddy.
I will have some problem. Can it be 17th?
But he will argue.
No, they're not on 17. It's come on 16.
16.
Okay.
I think 67.
Well, this is a matter.
Mr. Ziaul Haq, you are appearing this matter.
Yes, my lord.
All right.
My lord, this is a matter.
Yes.
The petitioner has challenged the order of the Lord Central Tribunal which relates to the promotion of the petitioner to the Indian Administrative Service cadre.
Mr. Haq, why don't you sit down?
From Odisha
Standing.
Administrative Service cadre. In a nutshell, my lord, the question crux of the matter: what will be the effect of punishment? Whether the effect of punishment touches the assessment matrix or not. That is primarily the only point. Otherwise, I don't have anything against the order because there is almost narrative. Here, my lord, admittedly the petitioner has got all the eligibility.
I think he'll be out of screen. Mr. Hawk, you take your seat. And when your turn comes, you just stand up. Are you getting the audio properly?
Mr. Haq, why don't you sit down? When your turn comes, you stand up. Mr. Haq.
He is not getting our audio.
Not
Check out
hearing.
this audio.
Mr. Ziaul Haq.
No, he's not getting that.
Why don't you sit down? Why don't you sit down? When your turn comes, you stand up and submit.
Yes, ma'am.
Oh, this is good.
My lord, I have already submitted a death chart long before.
Yes.
Can I humbly you can place the death chart
is before us, you can follow that, my lord. So it's
My lord, briefly, in 1986, the petitioner was recruited through Odisha Public Service Commission in the year 1986 to raise two cadre. The petitioner joined as a training reserve.
and these facts are not
Right.
just come to the core of the issue.
Well, the code is here, 3. Petitioner first,
He was given a censor. That is the
censor and recovery.
recovery. Where is that this order?
Order is at, my lord, page 162.
Recovery of 39,657.
And well, the second punishment is recovery of 13. First is censor. Second punishment is censor. First punishment is recovery of 39,657.
20 installments.
Only 20 installments and the 200 per month being the last installment of rupees 1657 of 95. Second is censor. The censor, my lord, is inoperative after 1 year. That is their guideline. I will draw my sentence. Now this
Come to their guideline regarding this point.
guideline, my lord. My lord, guideline is at page 236. My lord, guideline is first, my lord, I will draw my attention. What is assessment matrix? That is at page 237, capital A. And got it. Page 237.
Just a minute. 237 of a petition?
Yes, my lord, petition.
Starts.
Starts from 236, my lord.
Yes.
237, that is.
Dated 27/3/2017.
That is, my lord. the guideline is, yes, madam, 27/3/2017.
Page, your page number?
236. Yes, page 237, capital A, para is 3.21. The selection committee would go through the service records of each of the eligible officers with special reference to the performance of the officer during the last 5 years, including the vacancy year, and after deliberation in record the assessment of the committee in the assessment sheet comprising the assessment matrix. As the selection committee actually meets in the year following the vacancy year, the ACR up to the year ending 31st March, where the ACRs are written on financial revised basis, or 31st December of the vacancy year are taken to consideration by the selection committee. Now, the award of the punishment award was, my lord, on 23/5/2012 from the bedside, my lord. Page 162, I again draw my attention. And about censor, the guideline says, my lord, page 241. That is capital small c. The penalty of censure would be ignored for the subsequent select list for which the officer may be eligible to be considered. My lord, it will be easier if my lords, I will draw my lord's attention to the count of the UPSC. There they have given a tabular chart. My lord, counter of the UPSC at page 118.
UPSC means respondent number opposite.
Respondent number page 118.
This is filed in the administrative tribunal?
Central Administrative Tribunal.
This is filed in the administrative tribunal?
Yes. All right. We come to paragraph. Page, relevant page will be 128.
One 128 is a part of the judgment, I think.
No, pardon, my lord.
Oh, yes. No. All right.
There they have indicated every petitioner. Sangram Prasad Swami, assessment of last 5 years, 14-15, 15-16, 16-17, 17-18, 18-19. So by then censor has already over. So censor has not been mentioned in the remark column. Penalty of recovery of rupees 39,657 in 20 installments was imposed on 23/5/2012. Penalty was over in 24/5/2018. They mean 2018 because on that day the petitioner has deposited the amount. After getting this information later that this amount has not been recovered by the employer from the salary, he paid the amount. He deposited the amount because the selection was going on. Selection was enough. So by 19th March, before March, 20th installments from the date of punishment, it is over by January 2014. ACR period starts from March onwards. But they say, since you have deposited in 24/5/2018, so therefore it has got its effect on the assessment last 5 years matrix. My humble submission that the punishment is recovery and not the deposit. I have deposited because they intimated this amount has not been recovered. So I, out of my own volition, I have deposited. My humble submission, my lord, whether it will relate back the punishment of a recovery, relate back to the last date of instrument on the principle of relate back theory. That is the only point to my lord's humble consideration. My lord's, my humble prayer for my lord's consideration. They have also categorically said in their counter that censor has already been over. So on this ground, he has been declared ineligible. And whatever the decisions were they have cited, I have not no quarrel with the decision. I am not challenging the assessment of the selection committee. I am not challenging the relative validity. The decision-making process, which ought to have been done by not taking, by stating that this imposition of penalty falls in the assessment matrix, whether it is correct or not. And the selection committee also, the selection committee proceedings I have.
Whether the guideline speaks of what will be the process in assessing the the performance of the petitioner.
Yes.
What is the guideline says?
That guideline says they have elaborately dealt says in the ACR in the counter
regarding
space 38. 237 begins. Guidelines also regulation, both regulation also speaks. The similar page 237. The select B1. The selection committee will go through the records of the eligible officers and make their assessment after deliberating on the quality of the officer as indicated in the various columns recorded by the reporting review officer accepting authority in the ACRs for different years, and then finally arrive at the classification to be assigned to each officer. Committee to take into account orders regarding appreciation for meritorious work done by the concerned officer. Similarly, to also keep in view orders awarding penalties or any other adverse remarks communicated to the officer, which even after due consideration, his explanation have not been completely exposed. The selection committee would not be guided merely by the overall reading, if any, that we recorded in ACR, but it would make its own assessment. My lord, on ACR part, I have nothing to say. Because ACR they have not seen. ACRs they have not taken into consideration because penalty has been imposed on me. About second point, consistency in the assessment matrix, that 5 years. Second point. The selection committee, before finalizing assessments in respect of eligible officers, may compare the individual years grading with the year-wise grading assigned by the previous committee. The year-wise grading assigned by the selection committee should, as far as possible, in consonance with the year-wise grading assigned by the previous committee, unless present committee comes to conclusion that is not required for this case. My lord, the regulation, my lord, the regulation, my lord, page page 2. Okay. Page 231. That only quoted by the guideline. The selection committee shall classify the eligible officers as outstanding, very good, and unfit, as the case may be, on an overall relative assessment of their service records. I am not on this point. But my ACRs are aware before them. I was only not considered if they have categorical said in their counter because of this imposition of penalty that comes in that falls in the assessment matrix, you are not selected. Now that portion I want my attention to the counter. And that is also
What is your submission? Whether that should not have continued?
That should have expired by 2014 January. Because 20 installment expires. Then 5 years starts from 14th March to 18, select list of 2019. So 2019
what is the basis of this submission?
Submission means they say kind of the guidelines is
no, just simply that without going into the very complex issue that you are trying to raise, that this recovery was divided into 20 installments. You knew that in every month you are paying the penalty money.
Recovery.
You are paying the penalty money. We call it a fine or other, I call it penalty money. And it continued up to this date that you have mentioned and that time. So according to you, it should have been stopped in 2014, the day it was pronounced, because this penalty has nothing to do with the actual recovery.
Yes, ma'am.
How that can be when the word recovery is used?
Just you that period from the date of the punishment till the constitution.
Yes.
I have got five promotions and I am the special secretary. 5 promotions in Vice Gada. 5 promotions consistently and without disturbing maintaining my seniority all through. That 3 promotions that has been dealt and they have also answered the same in the state government. Yes, he has got promotions.
When you got those promotions?
My lord. Page. My lord.
Any help from the date chart?
Yes, date chart there, my lord. My lord, page 4/8/2012 at item number 6. Page 63. During the course of discipline proceeding, the petitioner was promoted to the post of OS Group A senior branch with effect from 9/5/11 and his seniority was maintained. And thereafter, my lord, 2011-2012, thereafter he got further promotion to OS super time scale by notification number such and such. This date, my lord, falls after the punishment.
Which date?
2011-2012. That is the punishment date is 23/5/2012 at item number 6. Next promotion, my lord, 23/12/16. The petitioner was promoted to the post of OS administrative grade by notification dated such and such with effect from 1/1/17. Those are the part of the original application in the central tribunal. 9/10/2018, the petitioner was further promoted to the post of OS special secretary cadre by notification dated such and such with effect from 10/10/2018. All such promotions have been extended to the petitioner in due time by considering his seniority and the petitioner had not been superseded at any point of time. His seniority is maintained all through. Now, the petitioner came to know that recovery has not been affected.
Now, Mr. Counsel, that is a question that whether they have debarred you from your consideration because of you suffered a penalty. Yes. That your penalty, as a matter of fact, was taken at the time of grading your performance.
No, not grading. Grading has been to be done by the only SCRs. But penalty, distinctly, they have stated in their guideline that if the penalty will be there, will be declared unfit. Unfit means totally either good or very good, that's different grading, because they have the power to
suppose in a particular year when you are given the penalty, that will be recorded also in your service book. Service record. Yes, service record. And this selection committee has right to revisit all the entries made in the SCRs or now it is called the performance.
I have no problem. They can visit us. They are not visited.
Taken that particular punishment during and just lower your grading that was granted by this accepting officer. Can you just question that?
No. My sole point, they have declared me unfit because of penalty. SCRs have not been assessed. Can we see there? The counter of this page 118, the counter starts, and the relevant person.
My lord, page 126. It starts from facts of the case. It is humbly submitted that the government of Odisha, page starts from 1 to 5. It is humbly submitted that the government of Odisha by later date submitted the proposal for preparation of select list. The state government intimated that the penalty of censure and recovery substances only in 20 instruments was imposed on the applicant, while state government's later date substances, the state government further intimated that.
One moment. Counter affidavit of opposite party.
Page, that is UPSC.
125. PDF page 158.
The state government further intimated that the period of currency of the state penalty was over on 24/5/2018. That was when I deposited. The selection committee meeting was held on 17/12/2020 for a preparation of select list of 2019 for promotion of the SCS officers to the highest grade of these 22 vacancies. The name of the applicant Sangram Kishore was considered serial number 3 in the journal constitution. The committee took into consideration the penalty of recovery only in conclusion which of ignorant substances and assets is showing overall as unfit. On the basis of this assessment, his name was not included in the select list 2019. And
let's come now to the UPSC's counter affidavit. What is their stand?
This is the UPSC counter.
The UPSC
yes.
Counter affidavit, okay.
And they have said about censor also. They humbly submitted the guidelines of commission in which the selection committee while preparing select list may take into account the effect of penalty other than censor. Because censor has already died down on 2012 itself, the year of punishment. And now how they will take it, the assessment matrix, that is the guideline. What my lord is asking, what is the guideline about that? That is there, my lord. Page 241. The selection committee needs to prepare the select list for the current year only. The currency of the penalty flows into the SCM year. The officers should get it as unfit in the overall assessment of for the current year. If the currency or effect of the penalty lapses before the SCM year, but is having implication on end of the year in the assessment matrix, the committee would categorize the officer unfit for the relevant years. In the assessment matrix, shown the penalty was current. Thereafter, the overall assessment officer may be made as per the procedure given B/3. So 5 years matrix, this assessment matrix means 5 years. 5 years ends, begins with 14th March 2014. And this 5-year period, they have given a tabular chart in UPSC that these are the periods where this punishment having its effect, the petitioner was declared unfit. That again, I lost my lord's kind attention for repeat drawal of my lord's resolution. That is page 128. And they have also elaborately dealt in the counter that only on this point he has declared unfit.
128.
My lord. 14-15 unfit. This is the 5 years assessment matrix. Unfit. Penalty of recovery of rupees such and such in 20 installments was imposed on 23/5/2012. Penalty was over on 24/5/2018. That day I have deposited. Otherwise, it could have been over on if the employer could have recovered, my lord. Recovery is the one, not the deposit. If I had that direction that you are required to deposit, then things would have been different. And my lord, about this knowledge, no pay slip is ever issued. Number of multiple deductions are there from the salary. It is not possible that in the what they have given the reply to rejoinder. I have given the rejoinder that I have given the rejoinder say nothing is attributable to me. It is for you to recover the amount And when during that period, I was the ADM somewhere. I have no pay slip was issued to me. There may be deduction of GPF, there may be insurance, there may be house rent advance. So this 2,000 rupees is deducted or not, that is beyond my knowledge. And whatever recovery is lies on them.
Can you just say, make this a submission that it is beyond your knowledge? Can you make such submission that it is beyond your knowledge?
No, I know the punishment. Whether the recovery is done or not, that is because it's 2,000 rupees. And whether they have done it or not, I don't. I have given my reply in the reserve.
That you cannot submit. That is why I'm pointing at it. From your salary, 2,000 rupees being deducted every month. You either know it or the deduction is not being made. There cannot be any other situation.
May be permitted.
Yes.
Have there been account slip issue? Classifications, deduction house rent, deduction GPF, this is the loan, these are the advances, motor vehicle advances.
That defense will not be available to you.
So that information is not available to me.
No, this defense will not be available.
Only account credit.
No, because we understand. You are not an unlettered person. You yourself know how the pay bill is prepared for payment. Even in this online system also, you know what will be your pay package per month?
Yes, madam.
You know that. Yes. And when you are getting the 2,000 less, you must inquire.
Well, my only question is
that you will not be allowed to take.
But this is maybe, my lord, I stand in line. But question is that the effect of punishment.
When that is pointed out, according to you, the moment the punishment is given, that's all.
And that is the law settled by Supreme Court.
That law.
Yes.
There is also contrary law is also there.
This is my lord constitutional based decisions which is followed up to 2022.
All right. Yes.
Appellants assisted with two charges of gross dereliction of duty and mistakes in preparation of floor sheet. So these are about this their punishment, but the order is dated. The punishment was approved by the labor court belatedly. The crux of the matter that whether the punishment will be effective from the date of passing of the order by the disciplinary authority or the approval by the labor court. Now, the last point, page 5, it has been clearly said, the respondents have, however, justified the order of dismissal with the labor court in view of the defect in the last point of 5-6 lines. It has succeeded in doing so. Therefore, the approval of the labor court to relate back to the date on which the respondents passed the order of dismissal. The contention of the appellant, therefore, that dismissal in this case should take effect from the date from which the labor court hours came into operation must fail. Here, my lord, the order of dismissal was passed. Thereafter, they have sought for approval under section 33 of the Labor Code Act, idea, and Labor Code Act was approved belatedly up to 3 to 4 months. Had that 3 months could have been gained by this petition, he could have got pensionary benefit. That was his contention. The Honorable Supreme Court, no. It must relate back to the date of punishment of the authority. So, in next case, my lord, it is how does it help you? Because the punishment
there is a master-servant relationship. How does it help you? That says the order passed, you terminated, and that under section 33, it was placed for the only for challenge whether there is an illegality or not. This order has been given effect to. It is not that it is hold on, that no effect was given. They have observed that.
Next case,
you are not serving, you are not working after that order.
My humble confession, next case, my lord, 2022, the Honorable Supreme Court say,
this searching for
6, my lord. by referring that case. No, well, I will draw my attention to straight to the last case of the more or less the same case as page 20, first I'll tell my lords. They have followed the same 97. 97 Supreme Court SCCL and S 1434. My lord, the same they have followed the order of the Kalyan case, it's constantly his case. And they say it must relate back to the order, date of the order. Because the order of dismissal takes effect from the date. So here my contention, the order of punishment has taken effect and ends in 2014 January. That is the contention Air France they have followed. And here we have noticed at least
different situation. Our question is very pointed and focused. It says what will be the effect of the order of discharge or dismissal in view of the existence of section 33. The Supreme Court has said no, it will be date back the order of the punishment. Right? Yes. It doesn't say we are concerned with after a domestic disciplinary proceeding is over, penalty is there and government employees in service. Question is the effect of that penalty, how far it prolonged for purpose of his next consideration for promotion. These are completely two different circumstances and situations.
But what, my lord, the word recovery is the word used in the order of punishment. Onus lies on the employer to recover. And they have also categorically fixed 2,000 per month ends with the 1635.
Yes.
So the recovery part is on the employer. So I have no role to play.
Yes.
Person has no role to play. So if they could have continued definitely, then I could have not
definitely. What will be the
6 years they have delayed. So they have delayed 4 years. Can you see the file document that helps me? They say we are going to inquire why this was not recovered. Why the kind is the state counter? State has
that means they did not recover at all. You paid off on your own when you found
some process is often and they say that your money is not being recovered.
Not true.
That then only I came out.
The question is not that. Time is not that. Whether that part of this thing, if they consider and they downgrade you for that penalty, whether that is illegal.
They have not downgraded, that's on the CSR, that's different. Can you see this selection communication?
That I've seen. That is
they say that without tendency with the since you have deposited the money in 2018, it has effect in the assessment matrix. My contention, assessment matrix, before assessment matrix, the punishment expires. Had the recovery been, this is the only point.
No, I got it.
Had the employer recovered, the penalty expires by 2018 January 2024. That is the crux of the contention of mine, and they have answered it. No, since you have deposited, penalty flows to the assessment matrix, and that is the reason I brought this related back theory. And the assessment matrix they have categorically said in the guidelines how it will have its impact. The other two cases I have cited, there. That is one case is
almost the similar circumstances.
Similar circumstances, but they have said what is the fault of the other cases? Fault of the employee. Two cases. These are two cases only.
All right. Thank you.
Yes. And my lord, I have another point. I have got all my permissions, maintaining my seniority and everything throughout.
All right. Yes, Mr. Hawk, two questions from this bench. One is that when someone has been given subsequent promotion in post, how the UPs take into again that stigma of penalty? That is the question number one. And question number two, the employer has not recovered the money. How that can be the prolongation can be again used against the employee?
Right, my lord.
First of all, the very important question is when the three promotions were given.
My lord, I am answering, my lord.
Yes.
The petitioner may be promoted to different posts within the state.
So here, my lord, it is a not promotion to the All India services, my lord. It is an induction from state civil service to All India services. So when that is a induction, there is a different guidelines cannot be equal with the promotion within the state, my lord. So the UPSC, they are the expert committee, the member are the expert, and they have no, my lord, malified intention with any of the officers of the state civil service. So as per the guidelines, my lord, in page 6 of my counter affidavit, so it has been categorically written regarding how the selection. So within this selection, within the assessment, the petitioner declared as my lord unfit. So he was not selected. Thou he was in the list of serial 3 of the list of that selection committee. And my lord, as per the guidelines, suppose in the year some vacancy year, in the year 2019 there were 22 vacancy. So as per the guidelines, the state government had submitted the 3 times, that is 66 numbers. So from page 6 of the counter affidavit,
which part of the guidelines are you relying on?
My lord, page 6, 3.5 guidelines of 4.7 of the guidelines commission. Just I am reading, my lord. Commission envisioned that the selection committee, while preparing select list, may take into account the effect of currency of penalties other than censure as under, my lord. The currency of the penalty is taken from the date from which it is imposed effective to the date it is ceases to be in force. Then, my lord, it is further humbly submitted that the selection committee, while preparing current list, my lord, only is guided by para 471 of guidelines of the commission as under. Guidelines 471, the selection committee meets to prepare the select list for the current year only. A, if the currency of the penalty flows into the SCM year, selection committee meeting year, the officer would be graded as unfit in the overall assessment of the current year. B, if the currency effect of the penalty lapses before the SCM year, but is having implication on any of the years in the assessment matrix, the committee would categorize the officer as unfit for the relevant years in the assessment matrix when the penalty was current. Thereafter, the overall assessment of the officer may be made as per the procedure given in section B3 above. Next para, my lord, 37 para. So there are 4, my lord, 4 categories: outstanding, very good, good, and unfit. So the present petitioner, in the assessment by the committee, selection committee, declared as unfit. He may be the transfer within the state, but when there is an induction, that is the separate guidelines of the Union Public Service Commission for the selection to the year to the induction of that year. So in that assessment, the petitioner declared as unfit, he cannot be selected. So far the second question, my lord, the petitioner being a responsible officer and sincere officer, and it is within knowledge, my lord, penalty was there, 39,000 some odd, and it will be deducted from his service, and which is ended in year 2014. So he remained callous. He has knowledge that is penalty imposed, and after intimation by the government in the year 2018, he deposited the amount. So this conduct also taken into assessment by the selection committee, my lord. And my the Lord Counsel for the petitioner has cited 3 numbers of decision. So my submission before your lordship that this is not applicable at all in this case. That these 3 cases, one is female health worker and another is a teacher, that is a separate issue, as because in those cases government is to provide the NOC registration certificate, all these things. So here in the present case, my lord, and which is the officers will got may got promotion to all India services and take the administration of the country, my lord. And it is the penalty, it is within the knowledge of that officer. He remained callous and did not even intimate the government from his side. As I am, suppose I am a sincere, very responsible officer and I have a bright career. Why he remained callously and did not pay the fine amount which is within his knowledge? When the state government issued notice, soon after then he deposited money. So this conduct also taken into consideration by the Union Public Commission, which is an independent body, the body of the expert. They have no malignant intention either for the petitioner or any of the officers. The entire guidelines is all over the whole country in all the states. So my humble submission, your lordship, so there is no merit at all in this case, and the UPSC respondent number 2 has rightly and honestly and selected the committee for the year.
Thank you.
My lord, may I only 1 minute? This is not induction; it is a promotion. For Regulation 55 says it is a promotion.
Induction generally used it. He says this is you are going from the state service to the central service. So it's all
by promotion, selection by promotion.
And
And the other point, my lord, the state government has filed a counter, a reply to sender and a counter. In the counter in D3 office note, they have said, I am reading out. It has come to the notice, my lord, page 23.
you filed it yesterday. This is last.
I am not filed. The state government has filed yesterday.
No, asking when you filed it.
Earlier we have filed. I am now citing on the earlier. We have filed on
11th of August.
That was the subsequent to that. That was the reply to the counter filed rejoinder. Earlier we had filed that counter. My lord, can do it fast.
My lord, the first counter they have filed. My lord, the first counter which they have filed
on
at page 23. At page 23.
8th May 2023.
Page 23. They have said it has come to the notice that the penalty statement sanction recovery of such and such in 20 installments furnished to department by the letter dated such and such under reference to Sangram was not reflected in the letter dated 23/9/2016 referred above. Please look into the matter and let us know why the said penalty statement was not communicated to the department in the year 2016 for the proposal for a selection list 2014 and whether the amount has been fully recovered from Siswani. Yes. Besides, please furnish a copy of the order of imposition of said penalty on Siswani, which is undersigned. Thereafter, my lord, in the last reply, they have said in para 4, page 4, the penalty remained unimplemented until it got detected after inquiry. Well, the last what they have filed by on 10th of this month, they have said, but para 4, the penalty remained. Page 4, the penalty remained unimplemented until it got detected after inquiry of this opposite party, and the entire amount of penalty was deposited by the person in one installment, as mentioned by the collector Sundargarh. So all implemented by themselves. And I got the information on 23rd, I deposited 24th. So this is the only point, my lord, that whether the currency of the penalty will flow to the assessment matrix.
You would like to suggest that you did not receive a copy of the penalty earlier.
I have received copy of the penalty.
So what does this submission?
So, but question that they should recover, they should have recovered this amount.
All right. That issue already you have raised.
And this the one decision that in the middle 2 decisions I have given, my lord, that speaks of the nothing is to be attributable to the petitioner in this in that case particularly when he has got no role to play. Recovery is not in my hand.
All right.
Oblige me.
So other matters will take up some other dates.
Well, item number 38, I beg pardon.
It's a matter with regard to discharge of the petitioner. We have a special secretary, and this discharge petition has been rejected of the wife. Here, in terms of abatement, he has brought in 109 in APC Act, Prevention of Corruption Act. He has also been had that matter twice. It's an urgent matter. It has been listed item number 48. And in fact, interim order also is concluded, but I want the matter to be disposed of and heard by your lordships. For your lordships' better appreciation, that would be. Vigilance is the state is the opposite party. Yes. Discharge petition against discharge petition we had come up.
I may be, I don't to make mention, my lord. Item number 27, my lord. Non-availability of drinking water.
Who is the petitioner?
The petitioner. I am for the petitioner.
Who? Petitioner?
Wife of the main accused, who has been as an abator roped in under section 109 without sanction and without anything. After 5 years, the charge sheet was filed on the date of FIR, and as an abator who has been roped in under section 109 IPC. So we had filed a discharge petition that was rejected, against which we have come. He said that I will be the second trial, but not from the police record and sanction point. He should not have been implicated.
All right, at least the matter of give a date or less number of cases at there.
So I may be pardoned to make mention, my lord. Item number 27, my lord.
Just a minute. Third of August.
An interim order to continue.
List on 23rd August 2023. Interim order is passed earlier shall continue till the next date.
I may be pardoned to make mention, my lord. Item number 27 is the urgent matter of non-availability of drinking water, my lord.
23rd.
My lord, item 26.
I'm sorry,
Item 20.
47 minutes. Yes, I'm sorry, 47 minutes. This is the last occasion I have undertaken to file my appearance in this matter. Because only I pray I am giving my appearance today. Let me take it on any short date as you also previous minutes.
It is 47.
47 minus.
Hey, Babu. Hey,
give it 18 months, the first week of September.
Item number 59. Notice for pre-admission stage has gone, but it has come in the after notice matter. It will be listed in the place admission. Short date and
My lord, item.
What is the short date in the
interim order?
Have you seen the number of cases and fees? 5th September.
Interim order to continue that.
Item number 54, my in item number 54, all the parties have appeared. I have filed also petition for modification of the order, my lord. The miscase has not been listed with this writ.
Modification of the earlier order?
Yes, my lord, directed for service of dusty service. But since all the parties have appeared, there is no necessity of any dusty service, my lord. It may be listed on some other day, along with this miscase. I have filed 5228.
Item 51. Just a minute. How many respondents are there?
4 respondents. 1, 2, 3 have appeared. 4 notice tracking report shows that it has already been delivered.
What about 2 and 3? Who are they?
3 and 2 has appeared. 2 has filed a Kalpana and has appeared. 3 has not appeared. Tracking report shows that 3 has appeared, my lord. 4 has not appeared. Tracking report shows that copy has been served on 4.
Who has appeared for the 3?
3, one advocate is there. Mr. G.K. Nanda.
In view of the registered notes, area 22-3 of 2023. Oh, sorry, it is 10/8/2023. It appears the service is complete. But the material listed on 14th of September 2023 for disposal.
Interim order to continue.
Interim order is postally shall go.
Item 51, item 51, that matter is additional fee under the motor vehicle act, rupees 50 per day. And that's a matter of mileage. Your lordship will already have argued the matter of mileage.
I have not argued, you argued.
Already your lordship, many dates are already fixed.
On 23rd, it will be again listed, 23rd of August.
My lord, item 26, your lordship, may I make a small prayer?
List on 23rd, yes.
Item 26, your lordship, this matter I was making a mention. This is a PIL matter wherein your lordship has already passed the order for eviction from the public road with a direction to the Tahsildar concerned to file an affidavit if the matter is not done before the next date. Now, in spite of this order, your lordship, by this honorable court, the private opposite parties suppressing that fact got an order of status quo by filing another writ, clearly suppressing this fact.
In that case, I have filed an affidavit. Your lordship.
Yes, your lordship. Yes, your lordship. My only prayer is that let that WPC number 16286 by 2023 come along with this PIL on.
No, that is a single bench matter. That is a single bench matter.
And that your lordship can direct. That
No,
is my
no,
only.
not direct. Just have you filed the affidavit in that?
Yes,
way?
today I have filed the affidavit. Just now I have gave the copy. What has happened, my lord? There is a direction that the land should be recorded in favor of the government. We have recorded it.
Yes.
Then the honorable court has directed why you have not evicted them from the government land.
Yes.
In the meanwhile, he produced a stay order of this honorable court.
That is my prayer, your lordship. That is my
So you
prayer.
filed and showing this order of the court there.
He is showing that.
You go there and intervene because it is not possible on a single bench matter to bring in.
My lord, I have already filed an intervention. Your lord, the honorable single bench directed them to intervene in this writ petition. There is a clear direction for them to intervene.
Already you bring on the next day. Today there is no time. It is fixed.
Yes, your lordship. My prayer is that. My prayer is that let it come.
21st of September 2023.
Your lordship may direct along with that writ petition, my lord.
No.
That is a single matter. How can it be listed?
All right. Next.
Serious prayer matter. This honorable court's order is not complied. And
who is supposed to comply it?
Government.
Government is a vector.
Health Secretary, my lord. Secretary.
This is regarding these hospital matters.
Yes, ma'am.
Sisubaban.
No. You are to give a roadmap to this honorable court.
That in front of the SCB Medical College.
No. Totally. A serious matter. And all orders of this honorable court. Maybe I'll.
That's we asked you to file that you want back to the health services through government hospitals.
If any act can be done.
Next week we'll.
Yes.
All right.
Hello, item 24.
On 24th is all right.
2 p.m.
24.
Not 2 p.m. It's 2 p.m.
Long argument will be there.
Long argument.
No, we will start from 10:30. Then we'll get up to 4:30.
Long argument. This is.
You are not complying with any order of this honorable court. I'll show that.
My lord, husband.
13th. 13th of September it will come. All right.
My lord, item 24 may taken up on 16th May.
33, na?
16th is day after tomorrow.
Well, item 24 to discuss.
What is the urgency in item 24?
My 24, my lord, in this the counter has been filed by the temple administration, in which that is in the counter it is not clear that on what basis they have filed the inventory report, on which year inventory has been done. Nothing has been filed, my lord.
In my lord, already ASI said that the conditional
My lord, in this case, amicus has filed a report today, and he was
not in this case.
That your lordship has the next month it will be taken up or first week of
on 21st month.
They have not submitted, no?
Not submitted.
But is not submitted in court.
But he has given a copy to me.
You're waiting for the call. It will come on 5th of September.
May I submit one thing? Your lordship has, this is relating to that Ratno Bhandar case, and this case more or less similar. That is posted to 22nd September. If this case can be posted to 22nd September, it will be.
This is not related to that matter, my lord.
Not related, but same. That is all related to the repairing of some areas or some portions of the Lord Jagannath.
Matters are totally different from that matter.
No, it is totally similar to that matter.
No, all right, it come, we will see.
Okay.
All right, it will come on
22nd September.
13th September.
13th September. Oh.
May pardon item 66 lordship, criminal appeal lordship, any convenient date lordship. 13 years in jail custody lordships.
66.
Criminal appeal 604. Any date convenient date.
No. After that also. It will come on 26th of September.